Permitted to mention, Lordship, for upgradation, appellate side matters, Lordship. Lordship, this matter I mentioned.
Give your slip, Kelsey.
That may I be permitted to mention, my lord?
Give your slip. Grounds of urgency are there.
Yes, Lordship. 3 times I mentioned the matter, Lordship.
Mention it 4 more times.
Lordship,
see.
please, it's a very urgent, Lordship.
We'll see, madam. Give the slip.
That item number 92 of your lordship's list, original side, my lord, praying for upgradation, my lord.
Give your slip.
Lordship, may I be permitted to mentioning for inclusion original side?
Call out the list.
Madam Lordship, I am for the petitioner Lordship. It is the restoration application. It was dismissed for default on 26th of February 2025. And we have filed the application within time, 5th of March.
Yes, it's a valid.
There are a number of petitioners, only one has applied for
That's
restoration.
okay. We can allow it. Call him.
Ordinary procedure would have been for him to file a fresh. And for those who are interested to file a fresh writ, and that is the law. I mean, in a joint action, one of them can't revive.
No, I've seen the law. You can allow it. Call that person also.
Limited only to
Only limited to his.
Only limited.
order, so
Only limited to him.
Yes.
only limited to.
And I last occasion, Lordship, please to inquire that the other parties are ready and willing to file this restoration. 2 parties already given me the wakalatnama regarding this.
Then you file all together. Then why are you?
Yeah,
In
sure.
course of the day, I shall file the wakalatnama.
Then let it come up later. All right. At the request of the learned comfort, the petitioner, let this matter be listed after 2 weeks.
The Lordship, please to make it within 1 week. I shall file in course of the day.
1 week would be
14th.
no. That will be 14. Okay, 1 week, 14.
No.
Let it be on the 14th. 14th.
Both on the
14th.
nice. Yeah.
Thank you. For the petitioner, this is the contempt application, you are supposed to file a report today. The report has been served upon me, there is an order for demolition of the unauthorized 5th floor. My only humble prayer is, since on the last occasion, the Honorable Court was very much dissatisfied with the conduct of the corporation, because of their delay all along. So, may I make a humble prayer, this order may be executed. 30 days time has been given to the PR. If it is not executed by the PR, they may proceed, for execution of this after 30 days.
My lord,
This is my humble prayer.
but here is my affidavit. And your lordship's order was actually, your lordship's kindly see your lordship's order for consideration of his representation. It took some time because of the fact, my lord, there are actually hierarchy, that is special officer building, DG signed it. And thereafter, I think, my lord, that this prayer, after the ambit of the writ petition, your lordship's order has already been complied with. So, my lord, this sort of prayer, my lord, actually after that, they will demolish. Your lordship's kindly see his representation. Only consideration of the representation. We consider the representation. Everything has been done. Order has been passed for demolition.
You have considered the representation.
My lord, that is my.
Then what is that?
Then what
Order for
remains?
demolition has been passed.
Challenge the order of the representation.
That is, the order is in his favor.
Then
Lordship,
nothing survives.
nothing
This is my
remains.
humble prayer, that it may be, if it is not executed by the PR, it may be executed by the, as per law.
If not executed, you file a writ petition.
I am grateful to you, lordship. I am grateful.
I am
Learned counsel for the petitioner states that his prayers, his grievances have been addressed. His representation dated 22nd July 2024 has been duly addressed. Full stop. A speaking order has been passed.
Lordship. Speaking order has been passed by the last page. That is special officer building. Order passed on 23rd July
A speaking
2020.
order has been passed by the Special Officer Building on 23rd of July 2025. Full stop. In view of the said, the present writ petition is disposed of. His prayers have been addressed. Learned counsel for the petitioner states that his prayers have been addressed.
Yes.
He had preferred the present writ petition seeking direction to decide his representation dated so. Yes.
And my affidavit is kept with you.
Affidavit filed by the respondent is taken on record.
I am getting.
Give the wish.
My lord, I appear on behalf of the petitioner, my lord. Pursuant to your lordship's direction, my lord, I have served Mr. Ghosh.
I will want report to this, my lord, because I have no instruction regarding the issue.
So you
I asked
decide,
for-
he also wants his representation to be
To
decided.
be decided.
No, my lord, I want a report, my lord.
You want a report?
I want a report.
I will
Let
file.
them file a report, my lord. Lord, kindly, my lord, takes up page 28,
Page 28.
page 28, my lord, annexure P2, my lord.
Page 28
28.
annexure P2. Yes.
Yes, my lord, kindly, my lord, comes to the last portion, ordered. My lord, this is the order passed by the special officer building. Lord, kindly, my lord, see, as stated by the PR that the building is more than 150 years old and very dilapidated. Some photographs are submitted. Reconstruction proposal has been sanctioned under Rule 3.2 and 410. Some RCC columns are provided for stability of the structure. Area of unauthorized construction is noted as 6.65 square meter. As stated by the complainant, in the existing asbestos shed is replaced by RCC slab as front portion of the structure. Now, my lord, kindly comes to page 29. I do not find justified reason to demolish the small existing building where the construction work has taken up to secure the old dilapidated structure. I am inclined to pass order to retain the structure, including the replacement at asbestos shed to RCC slab on payment of fees under section 401 to be paid within.
So I have not challenged the order before the.
No, my lord, this has been passed by the SOB. My lord, I am my lord, agreeing with this order. My lord, up to retention only, my lord, ground floor and first floor. My lord, what they have done on the garb of this, they are making an entire new floor over the first floor. That is my representation also. Now, my lord, for that construction, my lord, my air and light has been completely blocked. Kindly, my lord, sees the photograph at the page 44.
Yes.
This is the condition of the structure, my lord. My entire air and light has been obstructed, and there is no space between the two buildings. Corporation authorities permitted them to retain, my lord, the ground floor and the first floor. Now, my lord, they had constructed an entire new floor over the first floor.
Take down. The petitioner in the present writ petition is aggrieved by the inaction of the respondent municipality. Yes, respondent municipality in not taking any action. Respondent corporation in not taking any action against the unauthorized construction, against the alleged unauthorized construction in the form of an additional floor constructed at premises number 5, Shimanta Day Lane, PS Bovazar, Kolkata, at the instance of private respondent. Full stop. Petitioner is the owner of premises number 5/1, Shimanta Day Lane, PS Bovazar, Kolkata. Full stop. The private respondent purchased the adjacent premises in question and started raising unauthorized construction. Full stop. The petitioner raised complaints and finally, after conducting a hearing, comma, the special officer of the respondent municipality, vide order dated 31/1/2025, held that the private respondent carried out the construction work to secure the old dilapidated structure. Full stop. Hence, it allowed the private respondent to retain 9 number of RCC slabs from the ground floor to first floor for structural stability of the building. Full stop. All of a sudden on 12/3/2025, comma, the private respondent again started construction by raising RCC slabs and obstructing free air light to the petitioner's premises. Petitioner states that the said construction is above the ground and first floor and is absolutely a new construction being raised by the private respondent. Full stop. The order passed by the special officer is being misconstrued and violated by the private respondent by carrying out illegal and unauthorized construction by erecting one more floor over the dilapidated building. Learned counsel for the petitioner states that he had made several representations to the respondent, but the same have not been acted upon. Full stop. Learned counsel for the respondent seeks and is granted 4 weeks time to file his affidavit in opposition, reply to the same if any within 2 weeks thereafter, list after 8 weeks.
But by the time, kindly direct the municipal authorities, the police authorities, construction is going on rapidly. Kindly,
That's why I was saying, I told him, get the representation decided. He wants a report to be filed. Report, Shaunak, that how much time it takes.
definitely, but kindly appreciate, my building.
I
is
can
the
make it
adjacent-
time bound. If I make the representation, it can be time bound. There I can fix a time.
Well, I agree to that. But that also, I agree.
We'll
to
make
that.
it a time
Yes,
bound.
Yes,
At least something will be done. This way,
definitely, but construction should not go on. They should keep a watch.
so we'll make it time bound.
Definitely, in addition to
We'll
that,
make it 4 weeks so that in 4 weeks, how much will it be constructed? Let them decide it. If they don't do it, you come back. उसको change कर दो फिर आप. Petitioner had made several representations. Same have not been acted upon. Full stop. Learned counsel for the respondent states that they are ready and willing to consider petitioner's representation dated. What is the date? Full stop.
is 34, 28th April 2025.
28th Feb. No, 28th April, not
April.
February. 28th April 2025. Full stop. Learned counsel for the petitioner states he shall be satisfied if the same is decided within a time-bound manner. Full stop. In view of the submissions made by the counsel for the parties, this court directs the respondent number,
4, my lord. Executive.
respond number,
4, your lordship.
respond number 4, to decide petitioner's representation dated 28/4/2025 within a period of 4 weeks. Within a period of 4 weeks from the date of communication of this order, from the date of server copy of this order, comma, strictly in accordance with law, comma, by affording an opportunity of personal hearing to the petitioner as well as the private respondent, comma, by way of a speaking order. Full stop. With the above direction, the present writ petition is disposed of. Full stop. Go line डाल देना. The affidavits have not been exchanged. None of the contention admitted. Affidavits have not been exchanged, so none of the contentions are admitted by the parties. That's standard.
Only one humble submission, my lord.
Sorry.
If unauthorized construction be consequential steps under 401 should be
If I write that, then it won't be fair on my part. It won't be fair on my part. I'm expressing my opinion.
It's a point of.
The construction has stopped.
Mr. Das, look into it.
That should be
At least issue a work stop notice if they are
The
constructing it.
stop work notice is there, but that instruction I do not have right now, but I
I
can share them. Actually, prior to this, you should actually stop.
Their parapet wall is
That will do,
my window.
We'll get it demolished.
That is, building plan has been sanctioned under 9, etc.
No, the additional floor which is being constructed, that shouldn't.
That should be stopped by,
For Asansol, Milord, I am this now, Milord, I am in a petition.
we are always in the receiving end. Wrath of the court actually always.
Not at all. Mr. Das, you can't say that.
I am not, but on behalf of the respondent, we are always on the receiving. That is that.
I have also been on that side.
Your
And for the
lordship knows the pain and agony, my
My
lord.
lord, first, my lord's castigating remarks, my lord. I have shown my lord, those the video footage, my lord, to the officers, my lord. Asansol, my lord, that they will make up.
They should.
It has not gone in your lordship's order, but I have shown the video to them, my lord. I think they will rectify.
They should rectify it.
From inside, your lordship is very peaceful. From the outside, my lord, that is very angry.
The deputy mayor,
We are always-
the deputy mayor had called, my lord, called for a high level meeting, my lord. My lord, what happened, my
No,
lord?
Mr. That's not true at all.
My your lordship is- I'm grateful to you.
I'm grateful to you.
And on the petitioner before my lord. Your affidavit of service is already with the record. Lordship, first just a brief. My lord, I am a tenant in respect of a
Oh.
particular portion on the first floor.
This is your matter.
My lord, that.
No, that's the sealed building one.
My lord, seal one. Now, my lord, I am a tenant in respect of first floor, a flat measuring 1660 square feet. Admittedly, on payment of rupees 10,000 rupees per month. Now, without any notice being served on me, either under 220, 219, 225, 215 of the KMC, my premises has been locked. I made a representation. Representation till date has not been considered.
Yes.
Now, the only thing which I could lay my hands on was 2 notices. One demanding a sum of money from the owner of the premises, and another notice issued to some Mr. Poddar and a trust, which was affixed on the wall. I had no idea that on the basis of that 219(1) notice, which is addressed to someone else, the landlord maybe, my premises will be put under lock and key, where they are under an obligation to issue a notice to me under 220 and lock it. Now, lordship will kindly come to the brief facts of the case. And my lord, admittedly, the owner of the premises, as of now, the landlord is the lessee, who is the private respondent here. My lord, senior friend, he is my guru as far as KMC law is concerned. Well, I have no qualms in saying that. I have been his eklavya. I have never joined his chamber, but I have brushed my shoulders so many times with him that, but it is always a chance to learn whenever I am appearing against him, and my lord, subject to whatever falls from my lord.
No, that's true. I completely agree with what you're saying.
My lord, I have learned all subjects of law, my lord. I have learned in this manner, my lord, while fighting with people who are the best in the trade and ushered by your lordships. My lord will kindly
It's
come.
just that Mr. Mukherjee,
Don't take it to that level.
Ami jeta sotto boli dada.
In the ground.
No, I speak the truth. Whatever is my heart is in
Mr.
my.
Mukherjee, we have to find a solution to that dilapidated buildings. And those dilapidated buildings, it's very difficult to literally get it demolished because there are so many tenants, there are so many issues, then you have a law which protects them. And one day or the other, I keep reading in the newspaper, these buildings this keeps falling down and we are responsible.
It's a happy hunting ground for the lawyers. Wherever your lordship would find a dilapidated building, that rule 142 of the building rule comes in, I get an FAR double of what I am supposed to get under the law, provided with the caveat that I have to accommodate the tenants. There where the hodgepodge starts.
No, but under that garb of, giving, fine, they are entitled in law, they will get it. That's okay. But they don't vacate it. And any mishap can take place. And it's always, I keep reading in the newspaper.
That should be
This building collapse, that building collapse, and it is all.
Some of the buildings in North Calcutta or Central Calcutta onwards, because South Calcutta is a new one. From Central
You have
Calcutta
to strengthen my hands with.
that has to be from a judicial pronouncement.
Well,
It has to be a judicial pronouncement in this regard. Because otherwise, my lord, my humble reading of the law and the rules, building rules, does not give any protection to the landlord, who is the owner of the building. And I tell him that even the corporation affixes a notice under 411. Still, they are not reluctant to leave. They will come up before your lordship and say, this has not been indicated, that has not been indicated. This portion is repairable. Why they are going to demolish? I will repair myself. All these sort of arguments will do. Because I told my lord at the outset that it is a happy hunting ground for the lawyers, not for anyone else. And ultimately, during this incessant rain, continuing for 7 days, 10 days, anything can give away. And once it gives away,
it is happening.
Then the first person the police will go after is the man who is the recorded owner.
Yes.
This is the unfortunate part of the whole story.
I'll make you amicus in one of those.
Millard,
I'll try to
I
assist
had
you.
one matter. My learned senior friend is also there, Millard. Their orders have been passed by this honorable court. Lastly, the honorable division bench passed an order saying that whoever resides over there will reside at his own risk and peril. That is the only order I could get for the landlord. But will that save my skin?
I was there.
And Millard, still a building, 412 Millard. Our plan has been awarded. Another writ petition came. Another hearing is going on. And Millard, admittedly, 5 rounds of litigation before this honorable court. There are specific directions for the building to be demolished by this honorable court. Still, rigmarole of events are such that we are unable. Maybe once again we'll have to come before this honorable court. And it is not 7 days, lordship. It is a period of 7 years in my case.
No,
And-
but then we also become party to that.
Of course, yes. Not directly, but tacit.
Indirectly.
A tacit
Absolutely. Absolutely.
party to the whole issue. And ultimately, my lord, at the end of the day, we have to answer our conscience. No one is there.
True.
Absolutely no one is there. There is no friend, no father, no mother, no son, no daughter, no wife, no husband. Ultimately, it is your conscience
Absolutely.
which is always going to prick you.
Absolutely.
That's what I have done. This could have been avoided provided I proceeded like this.
That is the reason I asked you that question. Because it is.
Because that fight is with you. It's a fight is not with others. It's a fight. A person fights with himself.
Correct. We'll deal with that. Yes.
My lord, here the case at hand before my lord is
Yes.
page 32, lordship, if Leah's lordship's hand. This is the 10. I'm just trying to assure my lord's part.
Yes, please.
My lord, page 32 is my rent receipt, just on certain factual matters, which is admitted by my learned friend also, but just because I would like to. Then, my lord, 33 is my certificate of enlistment, where that's a commercial premises. I'm carrying on business there from. Now, my lord, will kindly come to page 34. This is the lease deed. Basically, starts from page 39 of the private respondent. who is the lessee, who is actually the person liable to pay taxes. Because my lord, there are three categories: owner, lessees. So if anybody comes within the first category of occupiers, is the lessee. Now, my lord will kindly see, he has taken this lease in 2014.
Yeah.
And if my lord kindly allows me to place notes, my lord will kindly come to page 50. Here, lordship will allow me to place last but 4 lines. Hereditament attached thereto unto the lessee for a period of 30 years. So the lease is still subsisting, 2014 till now, 44. Commencing from the date of execution, so and so. Now, my lords, kindly comes to the next page 51, paragraph 2, last but 3 lines. Steps for purpose of eviction of tenants, alleged lessees, licensees, illegal occupants. So he also has the right to collect rent. And then, my lord will kindly come to the next paragraph. The lessee is also entitled to give sublease of the said leasehold property or in schedule hereunder or its portion thereof to any party according to his choice and desire. Lessee is entitled to mutate. I mean, under section 183 of the Kolkata Municipal Corporation, it is an incumbent duty on the lessee to mutate. And as soon as he goes for mutating, he has to clear all the dues. And if he doesn't, then it is the duty of the corporation to suo motu mutate it and hold him responsible for payment. Now, my lord, here is the case which I am apprehending what my learned friend may say, though I am not omniscient, but my lord, I am apprehending that, now, my lord, a person is supposing in a building, nobody is traceable. The owner is not traceable. Then what happens is, you go, you ask the occupiers to take, and if they say I'm going to take the liability, then okay. Otherwise, you have to serve notice under 225 that your rent is attached. This is what my case is. And even then, if you deem fit and proper to issue a distress warrant to lock the premises, you have to give me a notice under section 220. I cannot be compelled without being heard. And then if you assess anything, you have to give me a hearing that what my assessment should be. I cannot be saddled with the responsibility of the entire premises. So there are various sub issues to it. Now, my lord will kindly see the schedule of the property. If my lord kindly comes to page 52. Schedule. Schedule हमारा कितना portion है बता रहा हूँ. My lord will kindly the 4th line, lordship. First floor measuring 3600 square feet, super built up area. So this is my tenancy where 1660 square feet belongs to me. So, my lord, I squarely come under the private respondent and whom I am paying rent at the rate of rupees 10,000 per month, which I had my lord, placed before your lordship at the very outset, that rent receipt. Now, my lord, that is at page 32. Now, my lord, what happens is, now, my lord will kindly come to page 57, P4. This is particular notice which was affixed to the wall.
Yes.
Where it is stated specifically that 81,26,000 is due and payable as on 22/2025. Nothing mentioned about me, who will pay, what to pay, what is that, nothing. Then, lordship, this is the impugned notice which was affixed, not even given to me. If my lord kindly allows me, this is a notice under section 219(1) of Kolkata Municipal Corporation Act, which is totally on a different footing. I will place it. Then, my lord, it is addressed by the respondent to the respondent number 5, being the assistant assessor collector, from the respondent number 4, who happens to be the assessor collector north. And now what he says, it is addressed to Mahendra Kumar Poddar Estate, who was actually the lessor of the present private respondent. And now it says that an assessment is due from 1st quarter 2007 to 4th quarter 2024. And what it says, lordship, may I read? This is to direct you to distrain the movable property. Nobody has given him the right to lock my premises. Of the said owner, occupier, hut owner, any movable property found in the premises in respect of which the said rate is due to the amount of sum of rupees and such further sum as may be sufficient to cover interest and penalty acquired thereupon to the date of payment and to defray the cost recovering the said amount, and if within 2 days next after such distress the said sum shall not be paid together with interest and such further sum as shall be sufficient to defray the said cost to sell the movable property, and if the said property is of perishable nature, and if after distress the said sum shall not be paid together with interest and penalty, and such further sum as be sufficient to defray the cost to sell the said movable property at once, and having paid and deducted out of the proceeds of sale the said sum of rupees together with interest and cost of recovering the same to credit and surplus, if any, of the municipal fund. If sufficient distress cannot be found of the movable property of the said owner or of the premises, you are to certify the same to me together with warrant. This has the approval of the municipal commissioner. So, my lord, within the four corners of this notice, it is regarding movable property, nothing to do with distress, 220, nothing, neither this notice has been served on me or addressed to me. Now, Lordship will kindly see the second picture at page 59. On the faithful day, by virtue of giving me no notice on 6th June, they come and lock my premises and seal it. Page 60. I have got the video recording that they were armed with police. They came and everything is under CCTV. Now, my lord, after that, I gave a representation to them at page 61, that is 27/6/2025. Now, my lord, I gave a representation where I categorically state at page 63, if my lord kindly allows me to just place paragraph 60, page 63, my lord, I will not place because that is what I have written.
Whatever.
Now, my lord, now, Lordship, here is the situation, my lord. Now, there can be two things. Either they will suo motu assess me,
Yes.
what the corporation is doing, which is illegal per se. They will give me an assessee number, being the tenant, and they will assess me and they will ask me to pay that amount. Now, my problem lies, my lord, as far as I am liable to pay only the proportionate tax under Section 8 of the West Bengal Premises Tenancy Act. Popat Kotecha, Supreme Court, Honorable Supreme Court's judgment says assessee tenants cannot be assessed separately. Again, the Honorable Supreme Court in 1998 says that the tax, municipal tax, cannot be more than the fair rent, which is to be assessed as per West Bengal Premises Tenancy Act. Remember, I being the owner, now I am not championing for the cause of the owner, but I am saying I am going even beyond it, but then that also helps me. Now, my lord, here is the case, my lord. They always come with the proposition of 193 because I'm with judgments, which full bench judgment of this honorable court, which has laid down the law that if at all I am entitled or I am liable to pay my rent, you attach it, I will have my remedies from them. If they come for me as a defaulter, I have my remedies. Now, my lord, here is a case where my premises has been locked. Now, without giving me a chance of hearing, now until and unless and what is the amount due and payable by me, that has also not been specified. Now, a humongous amount, which is to the tune of rupees, what I understand here, so the amount has also not been mentioned at this particular page. It is 81 lakhs, and then, my lord, in the second notice, it is there to the tune of around 83 lakhs. Now, my lord, in my respectful submission, if my lord kindly allows me, first to place, my lord, lordship, may take Calcutta Municipal Corporation Act, my lord. I apologize, my lord.
No, I have.
Now, my lord, let me place 219 first,
Yes.
as to what power they have. So, under 219, they have given me a notice. They have given a notice. I stand corrected from my learned senior. Now, my lord will kindly see. 219 says, if any person is liable to payment of tax does not within 30 days of service of notice of demand under Section 217 pay the amount due, such sum, together with all costs, interest due, and penalty may be recovered under warrant issued in such form as may be specified by the corporation by regulations, by distress and sale of movable properties. Now, it is his movable properties of Mahendra Poddar, or at the best, if in under section 183, if my lord kindly allows me to place if my lord kindly comes to 183 minutes, you will not follow any process and you will 183. Lordship has got it. Here, my lord. Whenever the title of any person to any land or building is transferred, such person, if primarily liable to pay payment of property tax on such land or building as the person whom the title is so transferred shall within 3 months after execution of the instrument of the transfer or after its registration, if it is registered, and after the transfer is effected, if no instrument is executed, give a notice of such transfer in writing to municipal commissioner. In the event of death of the person, now this is now will kindly come to sub clause 3. The notice under this section shall be in such a form as prescribed, and the transferee or the person on whom the title devolves shall, if so required, be bound to produce before the municipal commissioner any such documents evidencing the transfer and devolution. If any person who transfers the title of land or building fails to give any notice under this section to the municipal commissioner, he shall, in addition to any penalty to which he may be subject under the Act, continue to be liable for payment of property tax on such land and building until he gives such notice, but nothing in this section shall be deemed to affect the liability of the transferee for payment of the property tax on such land. The municipal commissioner shall, on receipt of notice of such transfer, here nothing has been given. Then, Lordship, on a written request, the municipal commissioner, there so and so, then notwithstanding 7, notwithstanding anything contained in subsection 6, the registrar of assurance of district judge so and shall fund. Now, so this particular act itself says the concept of suo motu mutation. They will find it and they will do it. They have not done it. I am not championing for anybody's cause. So the person who's the owner is primarily liable, to whom the notice under 219 is given, because under 217 he has not paid as prescribed in 217. Now, my lord, what they have done is 219(1). This notice has been given and my premises has been locked. What they have done actually, what is prescribed in 220. If my lord kindly allows me to place 220.
Yes.
It shall be lawful to any officer or other employee of the corporation to whom a warrant issued under the chapter is addressed to distrain, wherein it may be found that in any place in Kolkata, any movable property belonging to person liable, subject to following condition, exception and exemptions, namely, the following property shall not be distrained, so and so, so and so. Now, my lord will kindly come to page subparagraph 2. The person charged with the execution of a warrant shall be in presence of 2 witnesses, forthwith make an inventory of the property which he seizes under such warrant, and put the seized properties in a suitable place in the said premises under lock and key, and shall paste a notice of prominent place therein, and shall at the same time give a written notice to such form as may be specified by the corporation by regulation to the person in possession thereof at the time of seizure, and the said property will be sold as thereon mentioned. If there is reasons to believe that any property seized under a warrant under subsection 2 of section 220, if left in a place where it is bound, so my lord, this is to be followed, and then disposal of properties. Now, my lord will kindly come to paragraph to 225.
Yes.
Lordship has got. For the purpose of recovery of any property tax from any occupier under section 195. Now, my lord, I'll come to 195 later. The municipal commissioner, notwithstanding anything contained in West Bengal Premises Tenancy Act. Lordship has got 225. West Bengal Premises Tenancy Act or any other law for the time being in force shall cause to be served on such occupier a notice requiring him to pay the corporation any rent due or falling due from him in respect of the land or building to the extent necessary to satisfy the portion of the sum due for which he is liable under this section. Such notice shall operate as an attachment of such rent unless the portion of the sum due shall have been paid and satisfied, and the occupier shall be entitled to credit the account with the person to whom such rent is due, any sum paid to him to the corporation in pursuance of the said notice, provided that if any person to whom such rent is due is not the person primarily liable to pay for payment of the property tax, he shall be entitled to recover from the person primarily liable for payment of such tax any amount for which credit is claimed as aforesaid. If the occupier fails to pay to the corporation any rent due or falling due which he has required to pay in pursuance of notice served upon him as aforesaid, the amount of rent may be recovered from him by the corporation as arrears tax. So, my lord, there I have a liability under 225. Now, my lord will allow me to place 195. No, 195. No, recovery to place
195.
195 place kori nahi. I mean 183 place kori. Now, my lord will kindly come to 195. Recovery of property tax on land and buildings from occupiers. On the failure to recover sum due on account of property on any land or building from the person primarily liable thereof under section 193. Now, I'll come to 190. This is the game which the corporation plays. Whether I come within, I will come it later, because brushing my shoulders with my learned friends, I have understood that where lies their salvation and where lies mine. Therefore, under section 193, the municipal commissioner shall, notwithstanding anything contained in the West Bengal Premises Tenancy Act or in any law for the time being in force, recover from every occupier of such land or building by attachment of rent payable by such occupier a portion of the total sum due which bears as nearly as may be the same proportion to that the sum of rent annually payable by such occupier bears to the total amount of rent annually payable in respect of the whole of such land or building. An occupier from whom any sum is recovered under subsection 1 shall be entitled to be reimbursed by the person primarily liable to for the payment of such sum, and may, in addition to having recourse of other remedies that may be open to him, deduct the amount so recovered from the amount of any rent becoming due from time to time from such person. So, my lord, this is what they are entitled to. That also upon giving me notice, which I am intending to, but no notice was given to me. Now, my lord, will kindly come to page 193. Here, my lord, there have been several amendments. The latest amendment was in the 90s, my lord allows me to place it 193. The property tax on lands and buildings shall be primarily leviable if the land and building is let out upon the lesser. That is what I am private respondent I am saying. If the land and building is sublet upon the superior lesser. Here, my lord, superior lesser has sublet to the lessee herein. If the land or building is unlet upon the person to whom the right to let such building vests, the property tax on any building, land or building, which is the property of the corporation or the government or any statutory body mentioned in so and so, under section 170, the possession of which is delivered to the person agreement line. Now, my lord, three, the liability of the several owners of any land or building constituting a single unit of assessment which is purported to be severally owned in parts of flats and room for payment of property tax or any installment thereof payable during the period of such ownership shall be joint and several. Now, my lord, the second proviso provided further that in any case where the municipal commissioner is, for reasons to be recorded in writing, satisfied that the owner is not traceable. Here, my lord, the owner is traceable, being the lessee. The occupier of such land and building for the time being shall be liable for payment of property tax so long as the owner remains untraced, and shall be entitled to rebate if admissible. Then, my lord, the 2A, provided also that where the municipal commissioner, for reasons to be recorded in writing, is satisfied that the owner has failed and neglected to make payment of the property tax for four consecutive quarters, or if occupier of such land and building accepts the liability. Now, my lord, I have not accepted my liability. Or if the occupier of the land or building accepts the liability of making payment of property tax in writing, the occupier of such land or building for the time being may be made liable for payment of the property. I have not accepted, which is done. Now, my lord, will kindly come to 3. 3 always comes as a panacea to them, my lord, because this amendment was brought. 2A was in 2019 and 3 was brought in 2007. Now, my lord, 2A was, my lord, will kindly make a note, 2A was brought in 2019. Now, my lord, here, therefore, whatever judgments I will cite, even of the full bench, was passed in 1996. Now, my lord, I will try to impress my lord very humbly that I will come as an occupier, not under 225 or under 195, by virtue of 193 2A, which has come into existence by virtue of an amendment in 2019 only when I agree to. Now, how the corporation is making me agree to? They come and lock it without any rhyme or reason. Then they call me to the corporation. Then they take a consent in writing. And then they say, all right, 293 has been complied with. 293, I stand corrected. Bad habit of
193.
My lord, I apologize, my lord, and I'm grateful to my learned friend for correcting me. 193 2A. Now, my lord, so my lord, here, my lord, then my lord will kindly allow me to place 3A. In case any land or building or portion thereof which is not self-occupied, and where the occupier is restrained by law, order of the government, or order of the court from recovering the property tax due from occupiers or occupiers, such tax shall be recovered from the occupier or occupiers as the case may be, provided that the owner shall continue to pay such amount of property tax. Now, my lord, that it goes on, my lord. So, my lord, here a case is, my lord, 3 cases are made out. 1, my lord, under 193, occupiers have been made liable, but there are certain qualifications. 1, owner is not traceable, or you cannot claim it from the owner by virtue of any law for the any order or any such embargoes. And me as an occupier who comes within the ambit of an occupier being a tenant, only if I, on my own accord and volition, say that yes, I am ready to pay my share. Now, my lord, nothing has been done here. So, my lord, what liability I have is under 195, read with 225. This is my first branch of submission. Now, second branch of submission is, my lord, here they have taken it even a league further. Here, no notice. Here, what has happened? No notice has been given to me. According to me, if they have given me any notice, I'll stand corrected. Now, my lord, even if a padlock is put in my on my own, they should give me a notice as prescribed by law. That has not been given. Now, my lord, I intend to place certain judgments which have put this point to rest, subject to whatever अपना copy दिए दीजिए. Well, this is a full bench judgment of land and bricks. Lordship reported in 2001 CHN, page 594. My lord allows me to reach paragraph 33. My lord will allow me to read. My lord, it has page 607 on top. Lordship has got it. Upon taking into consideration various provisions of this act, the court observed, it is well settled principle that there cannot be any intendment of 33. Why I am reading, my lord, I'll amplified later. Intendment of tax, imposition of tax or assessment or steps for recovery thereof being governed by provisions of law, the Calcutta Municipal Corporation could not have gone beyond the statute. The provisions contained in section 193 in no certain terms states that only the owner would be primarily liable. In the event of failure of the owner to pay consolidated rate and other taxes, recovery can be made from the occupiers of the building, but such provision must be carried into effect strictly in accordance with law. The provisions of the said act nowhere states that the liability to pay consolidated rate is also on the lessee or sublessee. It is merely empowers the corporation to collect that areas of such consolidated rates and taxes from occupiers of the building only in a manner laid down under section 225, which I placed before your lordship, and not otherwise. Only in case where the occupiers of the building fail to comply with the directions as contained in subsection 1 and 2 of section 225, a tax can be recovered from the occupiers of the building in the same manner as could be done in case of a lesser or a superior lesser. Now, no notice has been served on me. If it is therefore preposterous to contend that section 231 and 232 of the Act confer an absolute, unguided, unbridled, uncanalized, and naked power upon the authorities to realize the amount of consolidated rent from any person whosoever. Now, my lord, 231 is, my lord, is mode of recovery, and 432 and 232 is first charge under court. Now, my lord, will kindly allow me to place 52, which is at page 610 of the judgment. My lord, may I place it? The only question which remains to be considered is as regard to the contention of the petitioner as to whether the tax is primarily payable by the tenant and not the landlord. The said contention, if upheld, would be clear derogation of the provisions of section 193 of the said act. Such a construction thus cannot be resorted to on the face of the provision. Now, lordship will kindly allow me to come to paragraph 67, which is at page 613. Lordship, may I place it? By reasons of section 8 and 9 of West Bengal Premises Tenancy Act, no tax is imposed. It will not therefore be correct to contend that now the tax is there. I will come to another judgment of the Honorable Supreme Court. Therefore, the correct to contend that the landlord cannot realize the amount of commercial surcharge as rent. How and in what manner such amount can be realized is not the matter of concern for the legislator, but despite of the same, it has not only, unlike the provisions of other acts, clearly stated that such an amount can be realized as rent, either along with rent or taking other modes of recovery to which he is entitled to recover the amount of rent. We may also have to bear in mind that the right of the landlord to realize a part of consolidated rate from the tenant has been in vogue for a long time. Now, my lord, may I be allowed to place the last 3 lines of paragraph 9 on the same page. In the absence of provisions of the Act of Municipal Authorities have no such power to recover directly from the tenants and occupiers, it is well settled principle that the statutory body cannot discharge any power and function which is not expressly conferred in the statute, and if the statutory body takes any action in violation of the provisions of statute, and actions shall be regarded as ultra vires. Accordingly, we are unable to uphold that the contention of the appellant that it is the responsibility of the municipal authorities to realize surcharge directly from the tenants under the provisions of the Act. Now, my lord, this is what. Now, my lord, I place another judgment where distress warrant was issued. That is reported in lordship 1998 CWN page 538. इसकी और एक कॉपी है दे रहा हूँ सर अभी दे रहा हूँ CWN तो देख लो तो बड़ा इसमें है तो दे दो दादा. If my lord allows me to place page 540, my lord, 540, the first paragraph, last but 4 lines. A demand for a sum of rupees 25,000 was made whether a distress warrant was issued. While taking recourse to the recovery proceeding, locks were put in some shops belonging to the tenants and 3 cars were attached. The writ petition was filed inter alia. Now, my lord, will kindly come to paragraph 3 of the same page, the appellant corporation has no right to stop the business of the tenants in respect of the shop room, which is owned by a private company and thus a separate entity. Now, my lord will kindly allow me to place the next page, 541, the fourth paragraph, so far as second writ. So far as second writ application is concerned, the same was filed by one Shahir Ali Mullah, who was owner of the Maruti car, which was seized by an interim order. The Maruti cars were directed to be released on furnish of security to the extent of which we were direct. Now, Miller will kindly allow me. Yes. Yes.
The 98 Calcutta report.
आपने तो 93 बोल मैं तो इतना बोले ही दिला you will my lord what I will 193 2A amendment came. That is the case which is being made out against me as far as the petition. I have a premonition that this will be the case, because otherwise these judgments are holding me in good stead till now. Now, Miller will kindly see page 545, last paragraph. A person charged with the execution of warrant shall, in presence of 2 witnesses, last paragraph, forthwith make an inventory of the property which is seized under the warrant, and shall at the same time give a written notice in such a form as may be specified by the corporation for regulation in the person in possession thereof, and at the time of seizure that said property will be sold in the Miller. No notice, nothing. Now, Lordship will kindly allow me to place at page 546 the fourth paragraph, section 220, in our opinion, should be construed strictly inasmuch as it does not authorize an officer or other employee of the corporation to attach any and every movable property found in the premises, but such property must be belonging to the person liable to pay taxes. Section 193 of the Act clearly states as to who would be the person liable to for payment of such taxes. Now, 193, even with read with the amendment, I hold even this point does not bring me within the ambit, because I have not accepted the liability and the person is traceable. Then, my lord, last but one paragraph, the penultimate paragraph of the same page. So far as occupiers are concerned, liability is confined to section 225 of the Act. Thus, unless and until a person's name is mutated, be he the purchaser or the lessee, his liability under the Act must be confined to section 225 and not otherwise. Only rent could be attached from the occupiers, but not the personal properties. Now, my lord, last but not the least, page 550, last paragraph, which continues and spills over to other paragraphs at page 551. However, the demand made in respect of interest and penalty being vague, no distress warrant could have been issued for realization of the said sum, and notice hereinafter the writ petitioners have paid certain amount, and as such they are directed to pay the balance amount within 4 weeks, so and so. The appellant shall be at liberty to calculate the amount of interest, so and so. Now, Miller will kindly come to the next page. However, as far as Appeal 582 is concerned, that is with regard to Miller, the tenants, evidently the petitioner has rightly been allowed. No demand has been served upon him. He is not the person liable in terms of section 193 of the said Act. In fact, in paragraph 12 of the affidavit, it has been admitted that the car so and so. Now, last but 3 lines of the same paragraph, assuming that he is a tenant in respect of one of the outlets, only the rent could only be attached. So, my lord, this is the law. Now, my lord, coming to that next aspect, what the Honorable Supreme Court has said, they are assessing people. How can they do that? I am asking a question to myself. This is on a different footing, but then isko और निकालो. Lordship will, this is reported in 2018-9 Supreme Court, cases 149. एक बार देखो तो मिला हो तो same paragraph में दे रहा हूँ sir. Sir,
Thank you.
उसका भूल गया sir. My lord will kindly allow me just on one point. What they are doing now, they are assessing me. How can they do that under the dicta? Can they do it? My lord will kindly come to page 3. My lord, page 3, paragraph 9. Here, my lord, what has happened is, my lord, this is the case on the fact, my lord, where it was decided whether the landlord can suo motu, without going under the provision of Section 20 of the West Bengal Premises Tenancy Act, enhance the rent due to the increase in property taxes. So now, my lord, here what the Honorable Supreme Court said is at paragraph 9, the respondent tenant nowhere denied in any specific terms that the share of municipal taxes demanded was disproportionate or excessive or otherwise unauthorized in law. This is between the landlord and tenant. The argument advanced at the bar that the landlord cannot apportion the municipal tax among different tenants if premises are to be occupied by more than one tenant and it is the municipal corporation who is the authority to separately assess the tax payable by each tenant does not find any support from the provisions of the Act of 1980. How they will assess me? Now they are saying they will assess me for one proportionate. This particular judgment is staring at them. Then my lord will kindly see this in Gujarati, in court in Calcutta education. This was with regard to, my lord will kindly see at paragraph 10 of the same judgment. As aspect of the matter came up for consideration before the court in Calcutta Gujarati Education Society versus Kolkata Municipal Corporation, and the view expressed by the court was found in paragraph 45 of the said report, which extracted below. We find that the machinery provisions for assessment of recovery of tax basically involves the owner or the lessor who is primarily liable for the tax of the property, although the course of assessment and recovery of the portion of tax from the tenants, subtenants, and occupants therein involved is also directed. It is with the purpose of to make procedure of recovery of tax simpler. The owners or the lessors proceeded against the person primarily liable. The owner or lessor of the property is primarily required to satisfy the demand towards tax with the right to recover it from tenants, subtenants, and occupants. If the landlord or the owner is obliged to make payment of the whole amount of the tax inclusive of his own share and share of tenants, subtenants, and occupants, the owner or lessor has to be conferred with the power to recover the portion of tax payable by the tenant, subtenant, and occupants who is actually enjoying the property and putting it used for commercial or non-residential purposes. Now, my lord, will kindly skip over the line and come to the italic portion, my lord. That is, my lord, F, my lord. The whole amount of tax is recoverable from the lessor and may also be recovered from the tenant, subtenant through attachment of rent. In case where the lessor and the landlord has paid the whole tax, including the portion of tax payable by tenant or subtenant, the landlord has been equipped with the power to get himself reimbursed by recovery of portion of tax paid by him on behalf of the tenant. Section 231 of the Act therefore creates a fiction that the tax apportioned on the tenant would be treated as rent and would be recoverable as such. The word rent has not been defined in the tenancy law, and the court has taken note of the legislative proposition and so and so, so and so, so and so. Now, my lord, last but not the least, my lord, if my lord kindly allows me to place 153 page, last but paragraph 11, last but 5 lines. My lord, this portion is on, my lord, I am not amplifying it, my lord, go through it. This is on the tax liability, which cannot be given to tenants. This is 2018. Now, my lord, on the concept of audi alteram partem, judgment of the Honorable Division Bench of this Honorable Court, that is reported in 2023 SCC Online, Calcutta 64. My lord, here, my lord, I will just mark the paragraphs, my lord. Here, my lord, it has been said, my lord, if today they assess me or they have to first find out, give me a chance of hearing for anything. Now, my lord, in this particular case, my lord, nothing, this is only on audi alteram partem, my lord, where, my lord, the last. Here, my lord, a particular tax was assessed. The person was not given any notice for assessment, my lord. So, my lord, as of now, my lord, I am not placing this. This is cardinal principle. Now, my lord, so in this particular case, my lord, again, at the cost of repetition, if my lord allows me to place 193, which says proviso, the amendments have been made in 193, my lord. Let me place it before my lord. In subsection 1A has come on 7/9/8 2019. 2A has been added with effect from 7/8 2019. These are the two provisions which have been added after this judgment was passed, my lord. The full bench and the other judgment. Now, my lord, once again, my lord will kindly allow me to read, my lord, subclause 1A and 2. 1A, my lord, says the property tax of the land or building which is the property of the corporation or government or any statutory bodies mentioned in clause A subsection 8 of 171 and in possession of which is delivered to any person under the agreement or licensing agreement or lease or any other instrument shall be leviable upon such person. I don't come within that parameters. Now, my lord, the second is 2A. And then, my lord, 3. Then, my lord, 3A. Then 3A, my lord, which came into existence from 1/5/2007. Now, my lord, what 2A says? Provided also that where the municipal commissioner, for the reasons to be recorded in writing, is satisfied that the owner has failed and neglected to make payment of the property tax, here it is, right, for 4 consecutive quarters, or if the occupier of the such land of the building accepts the liability. So here I have not accepted the liability, only that judgment that I am not covered by 225 will come into existence, will be negated if I give my consent. The statute in its wisdom, by way of amendment, did not say that so much of the liability will come on me. A consent is required. If the occupier of such land or building accepts the liability for making payment of property tax in writing, the occupier of such land or building for the time being in force be made liable for payment of such property tax. 3A, my lord, which came into existence, my lord, later. In case of any land or building or portion thereof, which is not self-occupied, and where the occupier is refrained by any law, order of the government, or order of the court from recovering the property tax due from occupiers or occupiers, such tax shall be recovered from occupiers or occupiers as the case may be, provided that the owner shall continue. Now, my lord, in my respectful submission, my understanding of the law as on date. Here, my lord, there are three limbs of submission which I amplified upon. One, first, no notice was given to me. No notice under 220 issued. The only notice which I could lay my hand is under 219(1). My premises was locked and I am admittedly a tenant. So, my lord, neither an audio alterum partem nor any notice under 225 has been given to me, nor under 195. So, my lord, but a drop of a hat, a particular punitive action is taken where my business is stopped by putting it under lock and key. Now, my lord, what remedy is, my lord? I have to go to them, give us consensus, and being assessed. Why should I do that? If I have to at all do it, I will do it under the orders of law, under the orders of this honorable court, my lord. So, my lord, that is as of now, my lord. So, my lord, whatever falls, my lord, at least my shop room should be opened, my lord, at this stage, even at the cost of calling an affidavit from them, and some interim measure should be there, my lord, because from 6th June, my premises is under lock and key. I apologize, my lord, for taking a major portion of my lord's day today.
Done. Look, the property stands in the corporation record in the name of page 158. At page 58, your lordship would get Sri Mahendra Kumar Poddar Estate, Nagarmal Poddar, trustee, and others. Page 58. So it stands in the name of this person.
Mahendra Kumar Pradar Estate.
Yes. Thereafter, my learned friend has placed the lease deed, which was given on lease to this Shashwat Infrastructure. Shashwat Infrastructure got a lease for 30 years. Effective from
2014.
So from 2014 The lease is for 30 years.
Well,
That
my
is
lord,
going
may
to
I take
expire.
my lord's leave for 5 minutes? My lord, I'll be back, my lord.
It will expire in 2044. Now, the person who was the lessee in terms of this deed of lease never bothered to take any step in terms of section 183, which my learned friend was placing, to get his name recorded and say that, well, I have taken a lease. Now I am the person liable to pay the tax. Nothing done. So it continued in the name of this Mahendra Kumar Poddar. Now the dues today, my learned friend has also placed at page 58, your lordship would get it. The total dues is 83,97,173, out
Yes.
of which the principal amount is 38 lakhs 94,741, which your lordship would get at page 58 itself. Your lordship would get the principal amount.
Yes, yes, principal, interest, penalty.
Yes. Now, my learned friend says that he is a tenant. And whatever his tenancy and all is there, my lord, corporation is not a party. Now, to limit his liability, he has placed those judgments. That is full bench judgment of in the matter of land and brick. And in this land and brick, there's a division bench judgment has been referred to, that is Mackenzie, more or less in the same lines. And of course, he has relied upon that Abdul Ghaznavi.
Yes.
HON'BLE, that is HON'BLE.
Yes,
That is in CW, and it is also reported in AIR 1998.
Yes, I'm giving it.
AIR 1998.
Acha,
Yes.
acha.
ठीक है. This is on a point of section 573, to which extent it will, but I am not on those points. Now, these judgments, in my most respectful submission, and my lord, with all humility I submit, my learned friend has placed, gets distinguished by his what he has shown. These judgments are of an era when 193 was not amended. Unamended 193 was interpreted in Mackenzie and also by Land and Brick in 2000. In 1990.
All old.
These are all old.
Yes, yes.
Now,
I've submitted.
the entire gamut of 193 has changed. What was not there has been brought into in 193, which, in my most respectful submission, your lordship would take. He has placed the right proviso. Your lordship would kindly now take. Now 193, my learned friend has placed. I am not going to trouble your lordship. Now 2A, your lordship takes. 2A.
Provided also that where
Yes,
the
provided also that where the municipal commissioner, for reasons to be recorded in writing, is satisfied that the owner has failed or neglected to make the payment of property tax for 4 consecutive quarters, thereafter is or. With the phrase thereafter disjuncts and takes away. Now your lordship would kindly come. I'm reading it for the better understanding. Or if the occupier of such land or building accept,
There lies the
which is
fact.
his case.
That is my case. That is the hallmark of my case. 93 2A,
I did
accept,
not say
I
I
render
did-
unqualified, I
I
render
did-
unqualified. I render
Let me
unqualified.
read it in my own way. I might be a.
Dada,
Or if the occupier of such land or building accept the liability of making payment of the property tax in writing. There is a very small comma there.
the comma, yes. Yes.
Now I put a bracket from or up to that comma. Now I am reading it, taking away that part from the statute for the timing for my argument. Provided also where the municipal commissioner for reasons to be recorded in writing is satisfied that the owner has failed or neglected to make the payment of the property tax for 4 consecutive quarters, the occupier of such land or building for the time being may be made liable for the property payment of the property tax. This is irrespective of his acceptance. This is irrespective of his acceptance.
No, but if
He
you
can accept. He might not accept. But if he does not accept,
no, but Mr. Mukherjee, read it once more. If occupier of such land or building accept the liability of making payment of property tax in writing.
in writing, thereafter there is a comma. He can accept. He cannot accept. He doesn't accept. He has not accepted. He has not. Others have done. In this property, some of the owners, some of the occupiers, they have applied under person liable to pay proper tax. Others have done it. He has not done. My lord, I read this again. Provided also where the municipal commissioner for reasons to be recorded in writing is satisfied that the owner has failed or neglected to make payment of the property tax for 4 consecutive quarters, if the owner or the person primarily liable to pay fails to pay tax for consecutively for 4 quarters, then the occupier of such land, my lord, I am leaving from ought to the comma.
Yes.
I say, my lord, this particular clause, this or is disjunctive, it is not conjunctive. Had it been conjunctive, then, my lord, whatever my learned friend is saying has full force. This clause from or to the comma is disjunctive, or takes it away. Then from 4 consecutive quarters, then the occupier of such land or building for the time being may be made liable for the payment of the property tax. I read it in this, subject to what your lordship thinks. Of course, that is, my lord, second part is provided by the act. If the occupier accept, he might not accept. Then, my lord, if the occupier does not accept, then
What
I
is the
cannot put my hands up and say,
If I read it the way you want to read it, that both are disjunctive and separately can or can be read. What is the purpose of having the or where it has to be accepted in writing?
or is given
If
for
I
the
if
part
I
in
if
writing.
you remove that, then there is no reason for putting that writing word in there for the occupier. Then the occupier itself becomes liable the way you are reading it, without even having that or.
Yes, my
So
lord,
what is the purpose of the legislature?
What has there are property, in my experience, I have found that the occupier, the owner, is not traceable. I can give a very instant example. The property behind the Exide, that Exide crossing, the property behind Janakallan Trust, owned by the riots. Nobody will get the original owner today. It is occupiers are coming. Corporation is now providing.
So
That you come, you get yourself name mutated. Henceforth, for the purpose of assessment, all the notices and all. But my learned friend was saying that I have not noticed. I have got no notice. He will only get notice provided his name comes into the assessment records. Otherwise, unless
so in that case also, notice has to be given.
in case he comes into the assessment role in writing. Unless I have his name in the assessment roll, my lord, I have shown whose name is there.
Today, Mr. Mukherjee, you are taking an action without giving any notice to him.
I have given a notice.
You have given notice to the main lessor,
Yes.
who's
How
the
do I
owner.
know that he is there housed in that house? He has been housed in that house.
That is the reason why that clause is there, that 4 times if they fail consecutively,
Original.
then in that scenario, then the occupier will come into place, who has to accept it in writing, and then you can live it.
This would be-
Otherwise, if that is the purpose, then the occupier is held liable for it for no reason. And first, I think, this is again subject to correction, the rent should be attached.
That is, even those judgments, what my learned.
Rent should be attached.
Is there.
Today, you have sealed the property. You have sealed the property without even exhausting the.
Your lordship comes.
I'll just.
was on 93, the revised. It has been shown when the amendments have come. But I would be failing my duty unless I tell and show that we are now today from 2017, 1st April, we are in a regime of self. Now, if your lordship takes section 182A of self-assessment, thereafter I'll be coming again to 2A. The lordship has got 182A.
Yes.
After commencement of Kolkata Municipal Corporation Amendment Act 2006, as required by the corporation. Now, my lord, the words are very important.
Just a minute.
It's
Just a minute.
Sorry.
182?
A,
Yeah,
capital A.
yes.
After commencement of the Kolkata Municipal Corporation Amendment Act 2006, as required by the corporation, any owner of land comprising any building and vacant land, or any vacant land, or covered space of building, or any other person, each and every word is very important, or any other person liable to pay property tax, or any occupier, in absence of such owner or person, shall file a return of self-assessment. Shall. It says shall file it. Here is a case. Now, my lord, this Mohendra Lal Poddar, in whose name the distress has been issued, has not come up before the corporation, not paid the tax. Forget, my lord, about 4 consecutive quarters since 2004. 2007, the taxes are not paid. Now, why this 2A has been given? My lord, 2A, now your lordship takes 2A of 193. Because this amendment is of 2019. Now, this has to be read with, my lord, 1. This is a, my lord, escape route in my respectful submission. To avoid a situation like this, 182 gives an occupier to file a self-assessment return only in respect of the portion what he is occupying. Now your lordship would read 2A, provided also that where the municipal commissioner, for reasons to be recorded in writing, is satisfied that the owner has failed or neglected to make payment of the property tax for 4 consecutive quarters, or if the occupier of such land or building accepts the liability to make payment of the property tax in writing, the occupier of such land or building for the time being may be made liable for payment of property tax. This is running parallel to 183. My learned friend has already placed 183. 183 talks about recording of name in the corporation assessment roll. Once the name is recorded in the corporation assessment roll, then the person concerned whose name has gone in, because it is by 183, I identify the person.
So according to you, suppose if the owner person, then of
Person primarily liable.
person,
He gives it to a lease. He becomes
that's
person
what I'm
liable.
saying. So owner, person, or the occupier. In case these two are not available, then the occupier. That's what it says.
Yes, occupier. And
Fails to file the self-assessment. From 2017, it's a unit area method self-assessment. Correct? So fails to file the self-assessment. Then what happens?
Then
the commissioner is empowered suo motu,
yes, under section
185.
185.
185, he can sumo to do the self-assessment?
I cannot do against only one. I have to do all the tenants, the building as a whole.
Correct?
Yes.
So you do the self-assessment? No self-assessment has been done,
No, it is not.
right? You
So
have,
here for a period, the tax your lordship has seen at page 58
yes,
is first quarter 2007 to fourth quarter 2024.
yes,
But though these quarters are in respect of the assessment of valuation
yes,
which took place prior to 2017,
yes,
because self-assessment will apply from first quarter of 2017.
yes,
Prior to that, some valuation is existing,
correct,
and based on that valuation, the quarterly property tax bills are being generated,
yes,
which are not paid,
yes,
which resulted into the accumulation of the tax.
right,
Now I have proceeded against the property itself, because, my lord, I cannot proceed against a person for reliance. It is against the property. The property is 4A Sinni Dotto Lane. It is in Bara Bazar, totally commercial area, and the building itself is being also used for commercial purposes. Even my learned friend is also carrying out a commercial interest.
he said that,
I have got no issues so far as that is concerned.
yes,
Now, it is correct that under 225 read with 195,
yes,
it is my claim is so far as the rent is concerned. But it cannot be taken to be an axiomatic truth.
yes,
In view of 193 amendment, the judgment shown by my learned friend today, my lord, I leave it to your lordship. To what extent it will hold the fort is a matter of question, because these judgments interpreted section 193 as it was existing at the time of delivering the judgment. My respectful submission with all humility that 193 has gone a sea change thereafter. At that point of time, no liability was fastened upon. Even there is not a sentence also, so far as the occupier is concerned. But now after amendment, and also I have shown my lord 182A, where he can himself choose to file a self-assessment in respect of that 1660 square feet, giving the details. I can still do it. Now, this 2A is a sort of an escape route to avoid, because these now that we are going into, after that we go into the recovery part. After 193, from 195, the recovery comes. And the scheme of the act, your lordship would see, after 193, 194 talks about the apportionment of liability. Now, my lord, today he is paying 10,000. What would be his liability of tax? If the building is valued at 1 lakh, then 10,000 upon 1 lakh, which becomes 110, his liability would be limited. Apportioned liability would be limited to that much only. Apportioned liability would be limited to that much only, not more than that. Now, as a occupier, now in the present factual scenario and the change of the law, my most respectful submission with the all humility, that my claim can go beyond the rent also. In terms of 193, where I find that there is a recalcitrant owner or an lessor who is reluctant to pay the property tax. Now I can, that is the reason, Malad, to give some tip in the recovery process. This 193 has been amended, by which occupier on his own can voluntarily say, well, you apportion my share, I will pay.
so in that case, Mr. Trivedi,
Here not there.
let him file his affidavit. We'll decide.
Yeah, I know they have nothing today.
Let him file his
It's a,
affidavit.
my lord, he will file, but I intend to put this point to rest, becoming a student of grammar here, where
Astrologer now.
law in its wisdom, statute in its wisdom does not say anything. Now rigmarole of the words. Now I will assess.
Astrologer also.
I am not an astrologer, my lord. Here, not even a single, everything should be read in tandem. You will not allow me to exercise my right under 220. You will not exercise your right under 225. But I will have to do it under 182A as it is not a tall order. I am a tenant protected under West Bengal Premises Tenancy Act, where according to that act, here 182A, which is only for the owners, self-assessment. Now I will be saddled with the responsibility. No law of the land is doing that. To 1998, 2018 decision, Supreme Court, they are just giving it. They will just go, they will lock up premises, and then they will say, you come now, search for me. I will play hide and seek with you. Your business will be stopped. Then I will put you at ransom without any law being an audio alterum partum will go for a toss. Cardinal principles of jurisprudence will not be followed.
The moment.
My lord, this needs to be. I see with, and then you read 183 in a manner which you deem fit and proper. That please erase these 3 lines. If that was to be obliterated, the statute in its wisdom would have said directly. There was no big beating around the bush. I ask a question very humbly to myself.
The virus of the
I will not. You under this, and there is nothing on record to say that I will.
I have read.
So, my lord, whatever it is, my lord, I am ready because at this stage, this cannot be decided. I can understand, lordship, because in other matters also I am fighting, my lord. So, my lord, will kindly put me to some terms. I am not on that. But, my lord, this needs to be heard in an expedite manner. This is my humble submission before my lord, because it's only on point of law. Whether the interpretation of 193(2)(a) is in a manner to be given as interpreted by my learned senior friend, or if in a manner according to what I am saying. If that particular point is put to rest, my lord,
That's the
it
bone
will.
of contention.
So, my lord, that is the only point. So, my lord will kindly put me to terms. I am not saying, because my first priority is not to argue only on law, but also to give relief to my client. So, my lord, put me to some terms, my lord, subject to my recovery from the landlord, and also, my lord, outcome of this writ petition.
That is always there. Recovery, my lord.
My lord, my exuberance, my
He
lord.
always has. the
Recovery
moment he
right
puts
you
in
have.
Money.
My lord, I have that right. Then again, Popat Kotecha's judgment, my lord, I have shown that
Yes.
is staring at my face.
No, that's right. But
What
the
happened
right
tomorrow,
file
my lord?
is
My lord,
always available.
my lord, I have.
Why go there? Let them file. We'll decide it in.
My lord, I bow down, because, my lord, I also have a grasp of the West Bengal Premises Tenancy Act. I, being basically a civil lawyer, what will happen tomorrow? I pay tax. I do not pay a single copper to the tenant. Tomorrow, 7(1) and 7(2), I will have to file. And now, with Chamaria's judgment, it says that all areas of rent, admitted areas of rent, you have to file within 1 month under section 7(1) of West Bengal Premises Tenancy. Otherwise, your defense will be struck off. Now, my lord, if I go and plead there that I have paid before the corporation, and that gives me a benefit of being paid, then they will come under 225, that it was only towards your rent. So here I am in double jeopardy. No, but I should also have a salvation.
They should have attached the rent. I don't know why they have.
My lord, that is, my
They
lord,
should have attached the rent.
they have not attached. They're not even.
That's the rent of Malad.
That is the first thing you should have done.
Not
Yes,
done it.
Not sealed the property at all.
Opinion about it. Now the Malad, the question is, when I go for the attachment of the rent, Malad, I see what the whole thing I have to get. There are some places, Malad, your lordship would find while taking up this. Malad, the dues might be 5 crore.
Whatever
Malad,
it
they
is.
are apprehending.
Realization is 5,000.
My lord,
It will take ages. The building will become.
my lord.
Whatever. The first
Lord,
step
the
should have been to attach the.
That is, Malad, that is land
My
and
lord,
break,
I-
that is Mackinnon Mackenzie, that is all clear about it.
Absolutely.
And, my lord, what they can do, my lord, I have first-hand
Stealing
experience
the
about it.
property of the tenant is
And-
absolutely an illegal act of.
And, my lord, remedy less, my lord, no notice given. One person comes with the police and
Absolutely
locks it.
legal.
That has become a devil's tool, my lord.
He is nowhere been served any notice. Nothing has happened. You just go and seal the property.
Because he is not there on my record. I have
How
that
can I be there on record?
Mahendra
My
Poddar
lord-
on record.
My lord, my
He
learned
even
senior friend. No.
Because
188, my lord.
person who has
No.
taken it on lease.
My lord, my learned friend is not placing those sections, my lord, which he is aware of.
Sure.
My lord, as far as assessment is done by the Kolkata Municipal Corporation in their record book, assessment record, they produce all the name of the tenants are there. And that is the basis on
Has
which
to be, it
that
has to.
happens, my lord. My learned
That goes
friend
on
is shying.
That is the only
Ah.
way they can attach the rent.
Yes. Now
That
they have
goes on changing.
today ask them to
That is
produce
also
that.
a Changing concept.
That is a constraint, but they have not even
As
seen
far
that.
as this property is
After
concerned,
2017, what my learned friend is arguing to now, just now,
Yes.
it is on a law which is antiquated.
Where? Oh, only from the bar. Let my
After
let my learned friend comment
2017,
that law.
that assessment
My
your assessment is from 2007, Mr. Mukherjee here.
from 2000.
Here you can't make that argument. You can't make that,
Area.
you can't make that argument in this case.
reprobate everything.
Maybe in a better case, you can make that argument, not in this case. Your assessment here is from the year 2007.
It is not my assessment, madam. It is my demand. My demand of
Assessment-
quarterly assessment
Ass-
is taken prior.
That's what I'm saying.
Yes,
Only after an assessment, the demand will come.
yes, of course, my lord.
Can the demand come before the assessment? It can't.
Cannot.
So your assessment is from the year 2007.
Yes, or might be prior to that also.
Whatever it is, but your demand has come today,
From
which will reflect for the court. I will assume that your demand is for the year of assessment, probably maybe 1 quarter before.
Yes, from 2007, my demand
My lord,
starts.
it is stated in 219. That notice, it is stated there. My lord will kindly come to that notice. My lord will kindly come to page 58. Page 58, my lord, the left-hand side.
58.
Left-hand side, my lord. My lord will see the assessment is given there.
Your assessment is here
Yes,
for quarter
Yes.
this to this.
yes.
Principal is this.
Not assessment, my lord.
No,
These
no.
are the demands for the quarters.
Quarter.
After
so is
assessment
the
only,
principal.
These
the
are the
princ-
demand for the quarters.
The principal is what?
Principal is
The
the
principal
quarterly
is,
tax
principal is,
multiplied with the quarters from 2007 to 2024. Each year generates 4 quarters. Each financial year generates 4 quarters. Now multiplied with the number of years.
so sir, after assessment only you will raise the demand.
Assessment has taken prior to that. These are the demands after assessment, and the principal amount is this. These are not assessment. These are the demand resultant of an assessment.
All right.
My lord, I have just one humble submission, my lord.
Yes.
My lord will give a short direction for affidavits because only interpretation of one.
2 weeks for the affidavit.
My lord,
2 weeks.
2 weeks, yes, my lord. 2 weeks.
affidavit করিস না তারপর পুজোর পরে
আমাকে বন্ধ করে দিয়ে
কিছু পয়সা দে
আমার যদি
Take down.
আমার যদি
The petitioner,
আমি লড়ে যাবো।
comma, by way of the
Very
present
good.
petition,
কিন্তু আমার কি করবো আমার তো মুশকিল
comma, challenges the action of the respondent municipality in forcibly evicting the petitioner
ওটা আছে বুঝতে পেরেছি গাছনাবি
and his employees from premises bearing number 4A, comma, Sinhi Datta Lane, formerly bracket में डाल देना, formerly known as 4A Ganpat Bagla Road, bracket close, first floor, Calcutta. Full stop. नहीं, उसमें
Well,
वो
my
करना-
tenanted-
and
my tenanted portion
thereafter-
is at paragraph
full
1.
stop मत करो. And thereafter sealing the premises on account of alleged non-payment of outstanding municipal dues related to the said premises. Full stop. What are you saying?
Well, my tenanted premises has been given in the first page, on page 3, paragraph 1 minute. Because then that,
I'm taking it from the prayer clause, 17,
Lordship,
para B,
Lordship, my lord.
17 para B,
Lordship.
same?
Yes, my lord. Sini Datta Lane, my lord, on the, it is just, my lord, the western side, flat of the petitioner, my lord, tenanted premises of the petitioner.
All right. The petitioner is tenant of the aforesaid premises under respond number 7, comma, who is the landlord pursuant to a registered lease deed dated 15/7/2014. Full stop. The lease is for a term of 30 years.
40 years maybe.
40 or 30?
30 years. 30 years.
You read 30 years.
Lordship, 30 years.
30 years commencing from 15/7/2014 at a monthly rent of rupees 10,000. Full stop. As per the terms of the said lease, comma, respondent number 7 is responsible for payment of municipal taxes, full stop. The petitioner is running his business of children garments from the said premises, full stop. Learned senior counsel for the petitioner, Mr. Dheeraj Trivedi, states that the respondent affixed 2 notices on the wall adjacent to the main door of the premises, comma. The first was a defaulter notice stating that an amount of rupees 81 lakhs 26,224 was due towards municipal tax as on 20th February 2025. Full stop. The second notice, comma, issued under section 219(1) of the Calcutta Municipal Corporation Act 1980, bracket mein KMC Act, was addressed by respondent number 4 to respondent number 5 and recorded that Shri Mahinder Kumar Poddar, comma, state
Nagarmal Poddar, trustee SM Kamla
trustee,
Trust.
state Kamlabai Trust, comma, being owners and occupiers of the premises, comma, had failed to pay municipal taxes amounting to rupees 83 lakhs 97,173 for the period first quarter of 2007 to fourth quarter of 2024. It was thereby directed that the movable property of the owner/occupier will be distrained. DIS TRAINED. Full stop. Pursuant to the said notices, comma, the respondent municipality with assistance of the police evicted the petitioner and sealed the premises by affixing a padlock. Learned counsel for the senior counsel for the petitioner submits that under section 219(1) of the KMC Act, comma, the municipal corporation has had no authority to seal the tenanted premises, full stop. At best, they could have attached the rent payable by the petitioner towards satisfaction of the outstanding municipal tax dues, full stop. It is further submitted that the registered lease deed clearly records that the landlord was liable for paying the municipal taxes, full stop. Learned counsel further states that he has not been served with any notice prior to the sealing of the premises, full stop. He relies on section. Shall we quote that or we leave it for?
Let
them file it, then we'll decide it. Learned counsel for the respondent.
We are saying that 190, it is main contention is 193. I'm saying if the landlord is untraceable, one, and secondly, if my consent is there. First is untraceable and second is
learned counsel for the respondent municipal corporation, Mr. Mukherjee, states that the action contemplated by the corporation is in compliance of law, is in compliance with the statutory provision of the KMC Act, full stop. He states that if the owner fails to make the payment for 4 consecutive quarters, then in that scenario, the occupier of the premises is liable to pay the taxes, right? Can be made liable to pay the municipal taxes, the arrears of municipal taxes, full stop. He seeks and is granted 2 weeks time to file his affidavit in opposition, 1 week reply to the same, list after 4 weeks. You are the private respondent number 7.
Yes, my lord, respondent number 7.
What do you want?
My lord, my case is that, my lord, this is on instruction, my lord. The person against whom this notice was issued, that person died in the year 2024.
Then
Thereafter, my lord, what actually
Why
happened?
you are not paying the municipal taxes then?
My
You
lord,
have
we have,
never informed me.
my lord, we have written several letters to the municipality on the basis that there are 14 assessees in the said building. If your lordship kindly see page 57, where the schedule is there, the entire fourth floor, my lord, I can show from the letter which we have submitted before the assessor collector, that the entire fourth floor has are assessed by at least 4 tenants. So if they have already taken the money from them as property tax, my lord, then therefore the question of paying the property tax by us does not arise, my lord. Why, my lord? Because if your lordship kindly see the notices, there is no mention of floors. They have assessed the entire building. So if they have once assessed the floors, then those floors should go away.
So this,
My lord, let
83
them also file an affidavit. My lord,
My lord,
my
please, my lord, all these documents along with
my
that.
lord, kindly pass an interim order for opening my shop for on any terms. Because my lord, I cannot, because my shop room has been locked. They have an issue, lessee has an issue with the corporation. And my lord, my shop has
And
been
I
locked
go
with,
high and dry.
so,
It's
so my
not-
lord, high and dry,
Your
there,
lordship fixes an amount, I leave it to your lordship. Let him pay that.
my lord, without
Within-
prejudice to my rights and, because where is the
within
law, my lord, to law?
24 hours, the corporation will go and open the padlock.
My lord, without prejudice to my rights and contentions, my lord, and pendency of this writ petition, I am ready, but my lord, I have no liability, my lord.
this, the entire amount which you have raised is for the entire building, 83?
Yes,
That
entire building.
instruction is
Building, my lord.
forthcoming.
Kindly see the,
That
my lord,
that
No, that is for the entire
That's it,
building.
for the whole building.
They have no instructions, only, my lord, they will lock it
there are
up.
14, my lord, assessors, my lord. I have already given them the letter, which they have received on 1st of August.
Learned counsel for the private respondent number, your number,
Respondent number 7.
my lord.
respondent
Seven.
number 7. States,
এই শিডিউলটা দেখুন স্যার আমি আমারটা মার্ক করা সরি
states and is granted
দেখাতে পাচ্ছি না হ্যাঁ হ্যাঁ
2 weeks time
Bro,
to
entire
file the
document
affidavit in
from
opposition,
assessor.
reply to the same if any within 1 week thereafter. Full stop.
তো এরা যদি অলরেডি পে করে দেয় আমরা কোথা থেকে দেবো
My lord will kindly direct.
In,
opening.
In the meantime, this court observes that as per section 219 of the KMC Act, the section expressly restricts the action of distress or attachment to the person liable to pay tax. Full stop. The seizure of property belonging to a tenant, comma, who is neither the assessee nor in default would be ultra vires of the said
And moreover,
provision
no 225 notice has been served on me.
and no notice was also served
and
upon us.
violation of principles of natural justice.
There are no notice
In
under
the present
220,
case,
225, nothing.
just in the present case, while the municipality may have the right to proceed against the movable property of the defaulter named in the notice, comma, there was no authority conferred upon it to attach the movable property of the tenant. Full stop. Accordingly, this court directs the respondent municipality to deseal the said premises and grant access to the petitioner for the limited purposes of preparing an inventory of his movable belongings and for their removal.
My lord, I am carrying on my
Do it
business there.
After 4 weeks, I'll pass a,
My
I
lord,
will not allow it to be open right now.
my lord, if my lord, my shop has been locked without any,
For it has been
my,
locked.
my lord, I am
4
without remedy.
weeks.
My lord, in that case, my lord, my lord will put me to, my lord will, then I will have to press, my lord, under what law? Under what law? My lord, I will be totally, my lord, they have an issue, my lord, and my law, it will be
How
locked.
much will you pay?
My lord, my lord, my lord, I am not liable
How
to,
much will you pay, Mr.?
my lord, I can, my lord,
Without
it is,
prejudice to your right in contention, how
my
much?
lord, I will pay, my lord, without prejudice, my lord, I will
50%?
pay 2 lakh rupees now.
1-2 lakh, it's a demand of 83 lakhs.
My lord, is it on me? I asked a question to myself, entire
Then we
building.
will decide the issue.
My lord, that
Then
is
we will
too much
decide
of,
the issue.
my lord,
1
that,
or 2 lakhs, you're not giving
so
charity.
then whatever my lord is, whatever my lord say, then my lord, whatever
That's why
falls,
I asked you first.
My
So
lord,
you should
2
be
lakhs.
gracious enough, Mr.
My lord,
Trivedi.
I am grateful, my lord. I am
1 or 2 lakhs, I'm sorry.
then my lord, whatever falls, my lord, because there is no law, my lord, there is nothing has been given, no notice has been given to me.
Mr. Trivedi, you want an interim order or not?
My lord, I do, my lord. I stand corrected, my lord. I apologize.
Otherwise, you take it in
No,
appeal.
no, no, my lord. I render unqualified
You
apology.
take it in appeal, you
No,
challenge
no,
my
no,
order.
my lord. I
will
render
not give
unqualified.
you anything.
My lord, I render unqualified. My lord will not take me amiss, my lord.
So tell me,
Exuberance, old age exuberance, my lord.
old age exuberance should not be there. You know, at this age, you should not have any exuberance. Be
My
like
lord,
Mr. Mukherjee.
actually what happened, my lord, I'll tell my lord.
Yes, he is your
As-
guru. Learn from your guru.
My lord, sometimes, therefore, I'm McLovin, my lord. I maybe have to cut off my,
You have not given enough.
my lord, I stand
Tell
corrected.
me
My lord.
how much will
My lord,
you
whatever
deposit?
falls from my lord, but my lord will kindly just take one thing in mind, my lord, that the entire
That's-
premises has been
That's why
assessed.
I'm asking you that
My
how
lord,
much
now I don't want to say any word, my lord. Maybe, my lord,
reasonable. Mr. Mukherjee, you be reasonable.
No.
my lord, then, my lord,
Kept mum, my lord.
No,
no,
you be
let him be
reasonable.
reasonable, my lord.
Mr. Mukherjee,
Yeah.
10 lakhs.
My lord, my lord, whatever falls, my lord,
10 lakhs is
my lord will kindly reduce it by some amount, my lord, whatever falls. My lord, I'm not bargaining, my lord, even at the cost, my lord, just by
What is this?
reiterating my prayer.
What is this?
My lord, reiteration of my prayer. It is not bargaining. Reiteration of my
10
prayer.
lakhs is a reasonable amount.
My lord, then whatever falls from my lord.
क्या लिखा है?
My lord, without prejudice to my rights and contention, my lord,
नीचे वाला बताओ last line.
and my to claim against my landlord also, my lord, my lord, may I take my lord's leave, my lord, and my lord, unqualified apology, my
नहीं
lord.
नोट नहीं वो वहाँ उसको चेंज कर दो. The in this court is of the prima facie view that the said property can be desealed subject to payment of rupees 10 lakhs without prejudice to the rights and contention of the petitioner for desealing the property to carry out his commercial activities in accordance with law, full stop. I think that should be enough.
Only some time to do that after payment.
The petitioner states that he shall make the payment within a period of
My lord, 2 days, within 2 days.
2 days,
This takes you to Saturday.
within a
Thereafter is
period of
Sunday.
within a period of 1 week, within a period of 1 week, and the respondent corporation shall deseal the property immediately within a period of 2 days after receiving the said amount. Full stop. With the above, that's it. Let this matter be listed for further hearing on after 4 weeks.
My lord had given me
My lord, evidence
time.
by evidence by 2 weeks, my lord.
Affidavit 2
Given
weeks. 2
me
weeks, 1 week
2
reply.
weeks time to file the affidavit.
I have
My lord makes it 3. With
All right, 3 weeks. 3 weeks to both respondent and private respondent and corporation. You want 1 week or 2 weeks?
1 week.
1 week reply. So that takes it 4 weeks. Give a date. Date after 4 weeks. August 28th. 28th August.
আরে অপোজিশনের সাথেই কাগজ দিয়ে দেবো অপোজিশনের সাথে কাগজ দিই
4th September. Sorry, 4th September.
I'm great.
You just keep it in the file.
My lord, I beg to respond number 7.
My lord, Mr. Riju Ghosh is appearing online.
Lordship, I am appearing virtually. Your Lordship, I beg your leave to appear virtually. In this matter, my Lord, I am appearing for the petitioner. If your Lordship recalls, my Lord, this is a matter where, despite the corporation's knowledge that the private respondents' constructions are against the sanctioned plan, and in deviation of the sanctioned plan, they have not taken any steps for demolition. It's an admitted position, your Lordship, and this has been going on from 2014. The corporation has knowledge from 2014. If your
Yes.
lordship,
Yeah.
I have made the opposition, my lord, as well earlier order.
lordship, we have not
It
been,
has been
we have not
served.
received.
Time
You are
and
appearing
Served
for the
today only.
corporation.
and for the private respondent.
Who's for the corporation?
Corporation is all appearing, my lord, Sijon Nayak, my
Uh,
lord, and which
Lordship,
Which?
on the last occasion,
my lord, as I know, my lord.
lordship, on the last
is for-
occasion, the
Mr. Ghosh. Calcutta Municipal Corporation.
Sijon Nayak is appearing.
Mr. Naik had appeared.
And his junior also
Yes,
here,
sir.
my lord, somewhere.
Where is he? His junior was here. I saw him.
That matter was continuing possibly some other court order.
lordship, on the last occasion, the corporation is directed to file and report, your lordship. No report has been filed or served upon us.
We'll have it
No, from her, my lord, they have prepared the report, my lord. They are about to file the
next
report.
week. We'll have it next week, not today. Keep it next week.
I'm grateful.
Next week. Not today.
Opposition, let it be recorded. Opposition.
Yes, just take down learned counsel for the private respondent has filed his affidavit in opposition. Oh, yes. Yes. Where is your report?
Yes, my lord. Report is
Wait. Yes. Give your report. Give the report. Give the file.
My lord, we have not received any copy.
Give a copy.
Yes, sir.
Learned counsel for the respondent, Calcutta Municipal Corporation has filed his report by way of an affidavit. The same is taken on record.
Lordship will have to give an opposition to their
Learned-
reply to their opposition and
Learned
exception. I
counsel
will
for
take
the
exception.
petitioner seeks 2 weeks time to file his exception to the said report. Learned counsel for the private respondent has filed his affidavit in opposition. The same is taken on record. Full stop. Learned counsel for the petitioner seeks and is granted 2 weeks time to file his reply to the said affidavit in opposition. Full stop. List after 4 weeks.
I'm grateful, your lordship.
4th September. 4th September.
I'm grateful, your lordship.
Grateful.
While appearing on behalf of the petitioner, lordship.
Private respondent.
Yes.
Two direction.
Who's for the
I am for the petitioner, lordship. Lordship, the petitioner owns.
My lord, before your lord, the opposition of the private respondent be kept on record.
May take it on record.
And the vakalatnamans. Vakalatnama.
yes, what had happened? You had asked. There
My
was a
lord,
hearing
Up-
conducted.
Updated report is with me, my lord.
Yes.
That is not within time. And regarding the affidavit, my lord, I am actually admitting the allegation of the petitioner. So nothing remains for filing my affidavit. I may be excused from
Oh, you
filing.
were supposed to, the department has proceeded with the case, a hearing was fixed, so and so.
My lord.
Is granted
My
2
lord,
weeks
this
time to
report I am
file.
not handing. Latest, my lord, updated
Yes.
report is here, my lord. I just received yesterday. I am handing the copy also, my lord. Yes.
Income.
401 and 416. 416 demands, my lord, special officer's hearing. And for that reason, my lord, the second page hearing notice was given. Initially, it was heard by the, my lord, executive engineer. And then, my lord, Director General building actually assigned the matter to the special officer building because there are certain anomalies in the building regarding roof and, my lord, the doctor's chamber 416, your lordship.
So after the hearing, you place it on record, the order of the special officer.
Lords.
All right.
I will. By you have affidavit,
Just
I
take
will
down.
file that.
The respondent corporation
One more thing, Lordship,
has handed over a copy of the report, which is taken on record, full stop. The report indicates that proceedings under section 401 of the KMC Act has been initiated, full stop. The parties have been asked to appear before the special officer building on 28th of August 2025, full stop. Learned counsel for the respondent corporation seeks and is granted 3 weeks time to file his report by way of an affidavit indicating the final order.
More time because my lord special.
4
officer
weeks.
building- My lord.
4 weeks to file report by way of an affidavit, bringing on record the proceedings before the special officer.
My lord, so far as the private respondent, let the affidavit in opposition filed by the private be kept on record. We have already served within the time your lordship had granted.
The affidavit in opposition filed by the private respondent is taken on record. You want to file any response to this?
My lord, we yet to file it. Response, my lord, I have missed it, my lord. They have supplied us. I am of the impression they are yet to supply. That being the situation, I am
You
waiting.
want to file?
Yes, my
But I am not willing to file any opposition, lordship.
lord.
Learned counsel the petition.
1 week time may kindly be given.
Seeks and is granted 2 weeks time to file his
Deep down.
reply to the said affidavit in opposition, list after 6 weeks.
Lordship can go.
6 weeks will go in vacation, so
Ma-
give a date of 13th of November.
13th of November.
Yes.
Yes, I am grateful.
But I am for the petition. আমাদের বিপটা কত বছর দইবে
Item number 9, I am appearing for the Kolkata Municipal Corporation.
My lord,
Last question, my lord, was
in
please
view of your
direct him
lordship's
to.
direction,
Ah,
my lord, I have served, my lord, upon the landlords of the premises in question, against whom, my lord, my lord, pray for, my lord, furnishing of appropriate, correct license roll, trade license roll. My lord, since, my lord, the landlord appeared, my lord, and my lord, see, I have not made party, but since they appeared and they prayed for, and your lordship, my lord, acceded to their prayer, my lord, directed me to serve. I have served. My lord, thing is, my lord, very simple, my lord. My lord, I only pray, my lord, for furnishing of the respective floor, which was missing against some of the occupants who are creating, running business and committing, my lord, nuisance. I am also running business. They are, my lord, parking their vehicle in such a manner. I am running a cycle repairing shop. It's very small, 80 square feet, my lord, room or shed. And my lord, they, my lord,
where is Mr. Banerjee?
Mr. Banerjee is coming, my lord, he's in the another court. He's
my lord,
on his
corporation,
leg, my lord, he's on his leg.
corporation
lord,
also, my lord,
court-
inspected it following my lord, writ petition, my lord.
And who's for the landlord?
My lord, I have served, my lord, I
Who's
think
appearing for the landlord?
on last 2 occasions he appeared.
No, এই তো আছে। Yeah, of course.
Postal receipts.
Landlord কি party?
My lord, since the matter is very short, my lord,
It's not short.
I beseech you, lord,
There's a reason behind this matter.
a corporation, my lord,
Who's
let them
appearing for Bharti
One-
Airtel?
one inspection report, my lord.
Not now. Who's appearing for Bharti Airtel?
inspection report will suffice, ma'am.
No, no, sir.
Bharti Act Limited was served.
Yes, yes, yes.
কখন service হয়েছে?
যারা পার্টি আছে তাদের সার্ভ করা হয়েছে, সব সার্ভিস করা হয়েছে। Everyone has been served.
In manner, we can file a report.
No, no.
As your lordship direction, I have a specific report here also. I
There-
can place it.
This is a circuitous way of finding information.
May I have a copy?
The copy I have filed.
Don't hand over anything right now. We'll have it next week or the week after that.
কি বলছো?
We'll have it business matter after 2 weeks. After 2 weeks.
After vacation,
Report.
After 2 weeks.
after 2 weeks,
Keep it on the 14th.
14.
14th will be next week, huh? No, keep it on 28th. 28th. 28th.
The 20th when some difficulties there.
আমি আছি 20th.
20th.
আমি আছি।
Let this matter be listed on the 28th. At the request of the parties, let this matter be listed on 28th.
ভালো।
20th से लेके
আমি আছি আমি যাবো।
ये ले।
এটাই তো report.
Lord, item number 10, I appear for the petitioner, my lord. By your lordships,
Corporation, you know, directed my lord to file an evident opposition to this issue. My lord, the evident opposition has been drafted yet to, my lord, be affirmed. I hope, my lord, get it, my lord, by a week. And I'll serve to my learned friend.
When will you file it, Mr. Ghosh?
By a week, my next by 21st.
And counsel for the respondent,
Next 24th.
KMC seeks and is granted further time of 1 week to file his affidavit in opposition. Full stop. Reply thereto, if any, within 2 weeks thereafter. List after 4 weeks. 4
Wait.
weeks.
grateful, my lord.
4 weeks. 4 weeks. I think 4 weeks will be September, 4th of September. 4th September, right?
11th also I am for the petition. This is my previous. Also, last occasion, your lordships please to ask me the locus of the petitioner
Yes.
of filing the instant.
Yes.
Lordship, the kindly come paragraph 4 of my writ petition. The premises in question where the unauthorized construction is going on, that is 71 by 8 by 9 Narkeldanga North Road, Ward number 29, Kolkata, 7,11,000. Shall Lordship kindly come to my cause title,
Yes.
the residence of the petitioner.
26A/10.
Yes, that is within 1.5 kilometers from the place of the unauthorized construction going on. Now, Lordship, I am just, before going to the merits of this case, so far the locus is concerned, Lordship, this Honorable High Court, Lordship, in
All right,
past-
1.5 kilometers is okay. 1.5
1.5
kilometers is okay.
1.5 kilometers.
I only resist cases where people live 40 kilometers, 50 kilometers. It's a racket. You know why I asked this question? I asked this question because this has become a method of extorting money. So I only see the locus to the extent that is he really aggrieved or not aggrieved? Some people living in 50 kilometers, filing cases in Calcutta. What is the purpose? Yes. Tell me the merit.
Now, Lordship, I submitted an objection that in this property, the unauthorized construction is going on without any sanction plan. That is starts from page 20.
Page 20.
এটা তো এমনি page 19 is the first page, relevant page is page 20.
Yes.
Under the instruction on behalf of my client, Muhammad Anwar Bhaksa of the such and such, beg to state that the fulfilled alleged illegal construction has been going on
Yes.
at the premises number such and such, Narkeldanga North Road, Ward number 29, PS Narkeldanga, Kolkata,
Instruction.
7,11,000 by the unscrupulous persons and miscreants, namely such and such. Both are such and such. My client state the illegal construction is still going on in a broad daylight and even at the night shift by piling, let's say, stocking building materials and blocking the KMC road. It is further alleged that 4 feet KMC road has been encroached to make the said illegal construction. My client states that it is not hidden, let's say, or secret construction, but with full knowledge of the civic.
Take this as a representation.
I will.
All right. The petitioner in the present writ petition is aggrieved by the inaction of the respondent corporation in not taking any action for the alleged illegal and unauthorized construction being undertaken at premises number 71/H/N, Narkeldanga North Road, Ward number 29, PS Narkeldanga, Calcutta. At the behest of the private respondents. It is the case of the petitioner. Petitioner, learned counsel for the petitioner submits that large-scale illegal and unauthorized construction is being carried out at the above-mentioned site without any sanction plan. Full stop.
Respondent number 7, ma'am.
By respondent number 7, 6, only respondent number 7 or there are two?
Respondent number 7 is the executive engineer civil
Yes,
403.
yes. Learned counsel for the petitioner further states that despite various representations, the corporation has failed to act upon the same. Full stop. Learned counsel for the respondent states that he is ready and willing to consider petitioner's complaint dated 13/1/2025 as a representation. Full stop. Learned counsel for the petitioner states that he shall be satisfied if the same is decided that his complaint, which shall be treated as a representation, is decided in a time-bound manner. Full stop. In view of the statement made by the counsel for the parties, full stop, this court directs the respondent number 7, no?
7.
Respondent number 7 to decide petitioner's complaint, which shall be treated as a representation dated 13/1/2025 within a period of,
As your lordship, 8 weeks, my lord.
within a period of 8 weeks, comma, strictly in accordance with law, comma, 8 weeks from the date of communication of this order, comma, strictly in accordance with law, strictly after affording an opportunity of personal hearing to the petitioner as well as the private respondents,
My lord.
comma, by way of a speaking order, full stop. With the above direction, the present writ petition is disposed of, full stop. No affidavits have been exchanged. Ho jata hai.
Lordship, may I pray
None of
one
the
thing?
contentions are admitted.
Lordship, may I pray one thing? If the Calcutta Municipal Corporation is on the firm view that unauthorized construction is going on,
Take action.
to issue the stop work notice.
They
Lordship.
will.
Automatically. Grateful, man.
The rest of the matters after lunch. Yeah, you take this. This is your affidavit in service?
Yes.
Affidavit of service is taken on record.
Good.
The rest of the matters after.
My lord, I bow my head down to trouble your lordship at this hour, my lord. My lord, under compelling circumstances, I am constrained to seek leave from your lordship to move this urgent writ petition on Monday, my lord. My lord, the facts and circumstances are, my lord, my structure in my premises is getting demolished without serving an order of demolition. Proceedings under 401 was pending. No opportunity of hearing was called by the respondent authorities, my lord. Suddenly, yesterday, they come to our premises with the purpose of demolition, my lord, and they intend to demolish the entire structure. My lord, I have a valid sanction plan, my lord, of G+4 structure, my lord. However, my lord, the corporation is saying, my lord, there are certain deviations, my lord. My lord, compelling circumstances, my lord, they might enter upon the premises anytime, my lord. Therefore, my lord, kindly, my lord, grants me leave, my lord. Grateful, my lord.
Fixed matter. Call the fixed matter. Monday लगा. Yes.
Lordship, in these matters, Mr. Jadip Kaur is leading me.
Yes.
Lordship, he is unable to come court. So may I request for 1 week adjournment? Can it be on 21st, my lord?
Why not?
And in the meantime, I can file this affidavit in opposition in item number 6.
Sorry? Yes, to me.
This is in respect to item number 6, affidavit in opposition. I have served on the other side.
Affidavit in opposition, item 6 में. Affidavit in opposition filed by the KMC is taken on record, full stop. Reply to the same filed by the petitioner is also taken on record. Let this matter be listed for, let this matter be listed on 28th of August.
Why not be bigger to act? Why might not much have been the other option?
On 28th, 5 and 6, 28th.
My seniors have been given, my name has not been given, although I appeared, both appellate my
Exchange कर देना. Put her name.
Shall I also forward the order? My name is also not there on the last occasion I mentioned it.
Correction कर दो this order. Order dated so and so is correction is carried out to the extent that the name of the council so and so is incorporated the same with case. Same. The other one also.
Grateful, my lord.
Just give him the details.
May I file my reply in 5?
Item 5 में 1 मिनट वो लिख लीजिए. Reply to the affidavit in opposition. Reply to the affidavit in opposition. Item 5 is taken on record. And that correction is in item 5, right?
Yes,
Item 5 correction.
Yes. Slipped in.
Twenty-eight fixed at 2, my lord, as it was appealed.
At 2. On 28th at 2 p.m.
Grateful, my lord.
2 p.m. How is he doing, Mr. Carr?
He's fine, lordship.
He's fine.
He's fine. Only that he wanted to do this matter physically.
No, absolutely.
That's why he said
Not a
to
problem.
get it adjourned.
Let's hope that day, my lord, ultimately it can start by the.
It will start, but it will take time.
Yes, it will take time. Definitely.
Take time. But then we can expedite.
yes,
We'll try to finish it before the vacation,
সবেতে আপনার নাম দেওয়া আছে।
so that you give me work.
না না আসেনি নাম দেওয়া।
Your name will be item 5 only, right?
5 and 6 both.
5 and 6.
I've given the order,
Given.
copy of the order. That's
5 and 6. Yes.
Item number 12, my lord.
I'm appearing for the Kolkata Municipal Corporation.
Well, I am appearing on behalf of the petitioner, my lord.
And for the private.
Yes. So on the last occasion, my lord has directed me to serve a copy to the corporation. I have served.
Yes.
But I am the petitioner, tenant in the suit building, in the property. But the property situates at 136 Rabin Sarani. But I am the lawful tenant in respect on the ground floor of the property. One shop room on the ground floor. Not the private. देंगे तो आपको सब
Yes.
And I am the lawful tenant in respect to the ground floor of the property. And I am using the property from the last 40 years. The private respondents are the landlord and the owners of the property. Now in the ground floor, there is one common meter box. They have constructed one room on the common meter box area and included the meter box in the room. Without any sanction, even my lord, the staircase has also been removed in respect to the subject property. Even my lord, the common bathroom which lies on the ground floor of the property, they have also demolished the same and using the same for their purpose. At present, my lord, we are not in a position to use the common bathroom which is lying on the ground floor. Even my lord, we cannot access the electric meter connection. My lord. The number of electric meter is lying there. They have constructed the room in the area of the electric meter and take the electric meter in the room. We are not in a position to get the access of the electric meter also and also to the common bathroom, my lord. They have made the illegal construction, my lord. We have made a representation. My client has also made.
Which page?
Yes, my lord. I'm sure. Let's start from page 22. Annexure P5, my lord. 22, my lord. 22, 23, 24. My lord, the same grievance. I am writing to express my grave concern regarding the illegal construction occurred in the premises number 136 Ravin Sarani, Kolkata 7 by the landlord. Sir, our shop room was closed from 22 March and they have made the illegal construction at that point of time. Even, my lord, we have made a representation through the advocate, my lord, at page 28, my lord.
What is, you are a tenant?
Yes, I am the lawful tenant.
What is your problem?
My lord, the problem is, my lord, they have made illegal construction. My lord, the common bathroom which lies on the ground floor, they have totally demolished the common.
Are you
bathroom.
using the common bathroom?
Yes, my lord. I was using even the other tenants are also using. My lord, they have removed the common bathroom and they have constructed a room in the area of the common bathroom. And using the same, even my lord, they have removed the electric metered space and constructed.
You're for the
a bathroom.
landlord. You have a good tenant.
Yes, certainly. But kindly take some one space 20.
Page
20. They are saying this was the previous scenario. Kindly see what is there. An empty space which is full of waste. My lord will get the walls of the nearby shops in the left and right and in the bottom end of the building, wall of the building. Kindly take the page 21, which they are saying the present condition.
Yes.
Now may I say what is the construction complaint of? I have installed a team. I have installed a shutter. There has been no construction at all. Even from their complaint, page 22 kindly sees.
you are carrying out this activity is a problem for them.
Well, kindly see, even the corporate.
Take the page 22. What is their complaint? They are not alleging any construction.
No, there is a illegal construction.
Allow me to complete.
Even the corporation has given.
Just a minute.
I am writing to express my grave concern regarding the illegal construction occurred in premises number 136 Ravindra Sarani, Kolkata, this by the landlord. Sir, our shop was closed from 22nd March 2024 to 26th March 2024. On the occasion of Dole, Holi, and on 27th March, I came to know that bathroom and electric meter common space is converted into a shop and a rolling shutter is also installed. And the staircase is also demolished. My lord will not get any complaint of any construction being made. And but in fact, there has been no construction. I have installed the team. and a shutter to protect that. Nothing else, nothing less. Alright, in all the representation and even in the writ petition, they have said this only. Nowhere said that I have constructed any wall or I have constructed anything else. Neither in the writ petition, my lord will get it, nor in any of the annexure. This is only because, my lord, they wanted that space to meet on a, to me, my lord, to hand over to them, which I have not done. And this is what has been done. Kindly see, there is no construction at all. What the corporation will do?
That they will decide.
But the corporation has also even issued a notice that the illegal construction has been going on. Well, I have given a notice. Even the corporation has also issued a notice. Yes.
401 has been given thereafter. Hearing
Hand over.
একটু দিন না just. দিচ্ছি। Incident সবগুলো বলেছে।
This should satisfy you.
I don't,
Give a copy to.
I got the copy. But one more thing, my lord, there is also a staircase leading.
Whatever it is.
Well, I have gone through. I have gone through.
Yes.
Lord, my only prayer, my lord, there is a representation of mine. Let it be considered. If not found, the corporation will I am not stand on the way.
On the basis of the representation only they have taken action. Why should your representation be considered now?
My lord, there is
They will
also-
conclude
my
the
lord-
proceeding as per section 401.
Yes, my lord. But it has been going on. But my lord, my only prayer, even the my lord, we cannot. There is no bathroom at present.
Whatever
There
it
is no-
is.
even my lord, there is no common staircase which leads to the first floor, second floor. There is nothing.
Whatever
They have
they
demolished
take
it.
action.
Yes, my lord. That is my only prayer.
Take down. The petitioner, preferred the present writ petition alleging inaction on part of the respondent corporation in not removing, in not taking steps to stop the demolition, in not taking steps to stop the alleged unauthorized and illegal construction being carried out at premises number 136 Ravindra Sarani, PS Jorasanko, Calcutta. Learned counsel for the petitioner states that illegal and unauthorized construction and reconstruction in the form of a common bathroom as well as electric meter space has been done illegally at the above mentioned premises. Petitioner states that he has been a tenant in the above mentioned property and the landlord has encroached upon the common space by removing
common bathroom.
By demolishing the common bathroom at the ground floor and constructing a tin shaded shop room at the common space at ground floor without any permission or sanction from the respondent corporation. Full stop. Learned counsel for the respondent corporation has handed over a copy of the instruction wherein it is stated that work stop notice was issued on 15/5/2025 and intimation to the local police station was sent on 17/5/2025, full stop. The instruction further reads that suitable action has been initiated under section 401 of the KMC Act, wide order dated 18/6/2025, full stop. Learned counsel for the respondent corporation states that the proceedings shall be, that further proceedings will be carried out as expeditiously as possible. Full stop. In view of the said statement, nothing survives in the presented petition, since the grievance of the petitioner vis-a-vis that no action has been taken by the respondent for demolishing the illegal and unauthorized construction stands met. The corporation is directed to complete the process initiated under section 401 of the KMC Act within how much time?
6 weeks, my lord.
Within 8 weeks, in accordance with law. After, in accordance with law, full stop. Learned counsel for the respondent states, private respondent states that they have not received any such notice and state that they should be granted a hearing before the respondent corporation passes the final order of demolition in case they find that the said construction, is illegal and unauthorized without any sanction plan. Full stop. It is expected that the corporation shall grant the private respondent a hearing before passing any demolition order in accordance with law. With the above direction, the present writ petition is disposed of.
I'm grateful.
Will grant hearing to both the parties. Grant hearing to the petitioner as well as the respondent before passing the final demolition.
I'm grateful.
Demolition order.
But one thing more, my lord, that my lord, I have denied, my lord, their, my lord, alleged complaint of illegal construction, and it is, my lord, may I only say, my lord, that it is that only I have installed a tin and shutter.
Tin and shutter is also illegal, sir. Who told you tin and shutter can be installed?
My lord, I'm not on that, my lord. Saying, my lord, since my lord has, my lord, observed, my lord, that
I have not observed
alleged
anything.
construction of the shop room, my lord, all the walls were.
Sir, you can't put tin, you can't put shutter. That's illegal.
Sir.
Yes.
I'm appealing for the Kolkata Municipal Corporation.
The petitioner runs a school, my lord, and there were assessments that were made in respect of the school premises. Now, my lord, the up-to-date payment of tax.
Why don't you ever go to the tribunal?
This one, my lord, there has not been any copy of the order served, assessment held, no
Give
hearing
them a
given.
copy.
Assessment has been held.
No, they let them hear me, my lord. They haven't heard me. It's ex parte.
Give them a copy.
We have sent a notice. I have got the copy of the speed post also,
Give
track
them the
report.
assessment copy.
And after that, bills have
We'll
been
take it to
generated.
the
They have been given letter,
let
lordship,
them,
for
my lord, I'll
payment of
take an
the
objection.
property tax.
I-
He has himself annexed the copy of
I
the
tell you.
letter. And after that, one reminder has also been sent. He has never written to us that he has not received anything.
Please, similar, there was an assessment that was made. We were making payment in terms of the last assessment till date. We have been making that. Suddenly, my lord, we get a letter, my lord, from the corporation. A letter of intimation is generated on their website, which shows that there was a retrospective assessment, which they have made sometime currently, with effect from fourth quarter 2016-2017. That's January 2017. They are making it now. Now, we were not in the know of any such assessment.
Where is that letter?
Yes, my lord, kindly sees. Please come, my lord, to the letter of intimation at page 26. This is the demand that they are showing now. Please see, my lord, the bills. Supplementary consolidated fourth quarter 2016 to first quarter 2018. 6 quarters, rate is given 2,76,340. Then again, supplementary consolidated fourth quarter 22, 1 quarter. Then fresh consolidated first quarter 2023 to 2024, 3,19,000 for 5 quarters. And fresh consolidated second quarter 2024-2025, 1 quarter. That is 3,19,000. Total, they are showing, Lord, the demand to be this. This is on the basis of a retrospective assessment of annual value. Otherwise, they could not have raised supplementary bills, which dates back on 4th quarter 2016-2017. That, my lord, can find, my lord, from the third column, the top entry. SC. S is bill supplementary. C is consolidated. Consolidated rate is
which page?
my lord, page 26. 26.
Where is SC?
Lord, the columns.
Yes.
Bill,
share, quarter.
Yes,
Types
bill
of
is
bill.
S. Bill is S.
Yes.
Kindly see that column S.
Yes.
So that's S means supplementary. So differential bill, supplementary. The next is share.
So supplementary could also be that what payment you have not made. They have
Here, this is because of a retrospective assessment. It's not under dispute.
where is the retrospective assessment?
Milord, they are equating it. Fourth quarter 2016 onwards, they are equating it downwards, Milord, and they are showing a demand. This means that there has been a retrospective assessment in their records with effect from fourth quarter 2016. Otherwise, up-to-date payments of current taxes we have been making, Milord. That, Milord, kindly come to page 25.
So what are you challenging?
I'm challenging, Milord, their retrospective assessment that they have made without giving me an opportunity of hearing.
Where is the assessment?
I have given the hearing. May I place the papers, Lordship? Lordship, in respect of first quarter 17-18, when the corporation proposed to do unitary assessment, when they have failed to do so, corporation sought to do the suo motu assessment. Then they found that the last valuation, because the capping has
It is only done after 17.
Yes. Before, when they were doing the self-assessment, they came to know that the last annual valuation was very low in comparison to the other premises. Therefore, the corporation has invoked section 180, subsection 2(9). And after that, a notice of hearing was given to them. May I place the said notice, Lordship, along with the track record?
Yes, what is this?
After the
180.
notice has been given, they have chosen not to give any objection to this. Therefore, the assessment has been done. May I place the inspection book also?
Notice has been done, given to you.
Yes. After that, may I submit, Lordship?
Yes. Let her complete, not I.
After that, the assessment has been done. And it has been intimated to them which they have annexed themselves, page 28, the letter given to them on 7 January 2025. So they were aware that one assessment has been done.
Page
28 of their writ petition, Lordship. As per the available KMC records, the premises was assessed with effect from second quarter to 2006-7 with annual value of rupees 2,83,540 and the quarterly tax of rupees so and so. It may be pointed out that this department has issued suo motu assessment notice dated 29th April 24 to you, but unfortunately there was no response from your end. The notice I have produced, Lordship. Thereafter, as per provision laid down under section 182(9), read with section 174(1) of the KMC Act 1980, the proposal for revision of assessment of the premises was approved by KMC authorities with effect from fourth quarter 16-17 with AV of rupees 21,10,580 and quarterly tax of rupees so and so. After that, a notice under section 184 read with 185 of the KMC Act was issued on 6 July 27 and sent to your end through speed post, and the details has been given, but again there was no response from your end. Thereafter, as per KMC norms, since no objection was filed within 12th August 24, the said valuation was fixed on 20th August 24. At present, as per letter of intimation dated 4 January 25, the total outstanding property tax due against the said premises is 68,41,554, including principal and penalty. If you are facing any financial hardship, as you claimed in your letter dated, you may apply to the Honorable Chairman Hardship Redressal Committee of the Kolkata Municipal Corporation along with the supporting documents from your end. You are once again requested to clear the outstanding property tax within 7 days from the date of receipt of this notice letter, failing which KMC may take necessary action as per law. After that also, Lordship, the KMC has issued a letter dated 23rd April 2024. The receipt copies service return has also been annexed herewith, wherein it has been intimated to them during spot inspection and available KMC records, it is found that you are in possession of the premises as lessee. You are requested to submit documents like registered lease deed, lease agreement, sanction building plan, other relevant papers for updating of pending assessment of premises within 7 days from date of receipt of this letter. In absence of any reply information from you in response to this letter, suo motu assessment of the premises will be done in your name purely on estimation basis of the purpose of imposing the consolidated rate and realization thereof from you. If any application has already been made, please produce the official receipt thereof for further action. Since they have failed to make the payment, action under section 217 has been done.
yes.
May I respond? There was an assessment made under the annual rateable value method, my lord. That is under the old method. After the assessment was made, in terms of that assessment, bills were raised and we have been making payment of the entire amount as demanded. That my lord will find from page 25. Please be satisfied when I submit, my lord, that the entire payment, the bills that were raised pursuant to those assessments in terms of the current property tax bill for 2024-25 stands paid by the document at page 25. Kindly see the amount. Amount was 47,173. That was the gross amount. And then there was a rebate.
Mr. Banerjee,
My lords,
where are you
page
reading?
25.
Page
Please,
25.
page 25, please.
Yes.
This is my last paid property tax receipt. If your lordship sees the top, combined e-receipt for property tax, PD, FS and LOI. Now kindly see, my lord, my premises number is given. My name is given. Now kindly see the payments I have made. Kindly come to the FD bill details, PD bill details. Now bill type is P. P over here means preliminary demand, which is quarter-wise preliminary demand. First quarter 2024-25, second quarter, third quarter, fourth quarter. For financial year 2024-25, 47,173 was the tax which I have paid, and corporation has received it to its satisfaction. This is a computer generated receipt showing payment. Now, my lord, kindly see when this payment was made on the 21st of June 2024, top right hand corner.
Yes.
So up to the 21st of June 2024, this was the annual valuation that was prevailing, on which there were taxes of 47,173. Now, my lord, kindly come to their letter of intimation in the next page. This is suddenly flashed on their website. That's at page 26. Please now see what they have tried to do, as I was showing your lordship earlier. The square box in the middle, my lord, the rows of that box, bill type supplementary, share consolidated from fourth quarter 2016 to first quarter 2018. Property tax per quarter is 2,76,340. Kindly see, from 41,000 it becomes 2,76,000. So that means they must have made an upward revision of annual value. They straight away can't increase the tax. They have to make an assessment. They say that they have made an assessment. According to them,
Giving
they have
notice. I've produced the notice.
according to them, they have issued a notice. I have said that I have not received any such notice. I have, in my representation, challenging their last letter, in which they said that we've done it in terms of an assessment which we made suo motu. We have raised the point that this has been made ex parte by you, number one. Number two, you could not have reopened this fourth quarter 2016-17 now. You are hit by Sahujan. You are hit by your own amendment to the Act. Own amendment says 6 years from the date of the revising order. Sahujan says 3 years from the date of the revising order. Today we are in 2025. You are giving me a notice of actions post an ex parte assessment made retrospectively with effect from 2017. Kindly see how many years? 3 plus 5, 8 years.
Banerjee, you are well aware that you have to make the payment.
Regarding
You are
this,
also, when people come and they say that we are not aware, no notice has been served, nothing has been given to me. This is a responsibility, duty cast upon you also to
Yes,
pay the property tax.
yes, I have done that till date.
You have done that only according to your self-assessment.
My
You
lord,
have not really followed the assessment which has been done by them.
with
Yes.
great respect, this payment is not on the basis of self-assessment. It's on the basis of their last confirmed assessment.
Where's the last confirmed assessment?
My lord, kindly sees fourth quarter 2016, the bill at the beginning here.
Yes.
This 47,173 is shown as the preliminary demand. This is not on the basis of any self-assessment. It's a preliminary demand raised on the basis of.
If you are saying preliminary demand, then that means the assessment had not been taken place.
Preliminary demand is a word they use, my lord, for the purpose of showing that this is the first demand they are making. On which there will be no interest and penalty.
Where is the first assessment on the basis of which you are making the payment? Have
Yes,
you
yes,
put the
that's
first
there.
assessment?
Yes.
Where is the assessment?
I'll produce. প্রথম যে অ্যাসেসমেন্ট এটা আছে দেখ তো কোথায় আছে না এটা না I'll produce it. I reiterate with great respect that there is an assessment made on the basis of which I was making payment. I'll produce, my lord, by records from which I can show that there were bills raised on the basis of that. The comprehensive property tax bill will mention the amount there. Lord, I'll produce that. My difficulty is today in 2024, in late 2024, behind my back, they have escalated it from 2016-17 onwards. My capping has been destroyed, and this
where is your reassessment, madam?
2020.
My lord, I have given the notice, lordship, produced the notice along with the speed post record.
Notice is July 2024,
And
which
may
means their assessment is in 2024 end, and they are assessing it from fourth quarter 2016 under the ARV. They are hit by limitation. Even
I
otherwise,
have
they
given
didn't
the
clear
reason why I have met the further assessment, lordship.
the subsection
Just,
2.
just a minute. Where is the assessment order?
There's no assessment order.
Notice is here. Where is the assessment order?
On the basis of that, I have issued the notice, lordship.
আগের প্রপার্টি ট্যাক্স যে বিলটা দিয়েছি সেই বিলটা আনাতে বল এইটায় যে বিলে জমা দিয়েছি ওটা আনাতে বল
You challenge this order?
May I have a look at it? I don't think it's an assessment order at all, with great respect.
It is.
I'll just have a look at it.
The last letter also I have produced, Lordship. They have not come before us with any documents as sought for.
With great respect, my lord, this cannot be an assessment order under the Act. I'll tell you, Lordship, why.
And may I produce the
May
copy of the
I can
inspector
challenge
book
that, take
also,
those points
Lordship?
here. Yes, I'll challenge this statement.
If he so agreeable, he can challenge it before the tribunal.
No, I kindly keep it open for me to challenge it in accordance with law. I'll come back in a writ petition. I'm giving my learned senior, my friend, prior intimation. I'll come back in a writ petition. This is not an order which the commissioner can make.
You should challenge it.
No, not there. Yes, but I'll challenge it. Now that I've got it,
May I
my
produce
lord,
the
kindly.
inspection book also, Lordship?
It's okay. Learned, you take it.
It is
Learned
written here.
counsel for the petitioner seeks to withdraw the present writ petition.
No, she's given me this according.
I shall
Recording.
forward it officially, Lordship.
Here, what more officially than
This is
court?
official. Just give
Is what more official than court?
not this.
ये वाला लीजिए.
Learned counsel for the petitioner seeks to withdraw the present writ petition since the respondent corporation has handed over an order dated 28/8/2024, wherein the revision assessment with effect from the fourth quarter 2016 under section 182(9) Roman 9 read with section 174(1) of the Calcutta Municipal Corporation Act has been carried out by the municipal commissioner. Full stop. Learned counsel for the petitioner states that he shall challenge the same in accordance with law. Full stop. The present writ petition is disposed of, is dismissed as withdrawn with liberty to the petitioner to file appropriate proceedings in accordance with law.
Grateful, my lord.
Keep all points open. Kindly keep all points open. Otherwise, they will come and say that these petition points you can't take there. These submissions are made sometimes.
All
points taken in the writ
points and
petition will be
contentions raised in the writ petition are open to challenge. And this court has not expressed any opinion on any of the points or contentions raised by the petitioner in the present writ petition.
And the same are open. So that will go. Otherwise, open closed.
The same are open to the petitioner.
So Ghosh will take half an hour
before the appropriate forum in accordance.
Mr. Ghosh will take half an hour of your lordship's time to say that your lordship had actually closed.
Where is he?
He's not here. I am saying this so that he pops up and suddenly says, "Why are you doing this to me?"
Yes.
My lord has recorded, my lord, that this copy she has handed over to me today.
Yes.
Otherwise, my lord,
वो जो order लिखा है ना, वो जो the copy of the order has been handed over to the petitioner in court today.
Sure.
You're not hit by.
Yes, so that's why. There also, Mr. Ghosh. All these, my lord, we've learned.
That's why I have recorded. You're not hit by that.
I beg to appear on behalf of the petitioner. My lord,
Yes, Mr. Chakravarti. Now what?
my lord, in this case, my lord, the Kolkata Municipal Corporation mutated our name, granted sanction building plan. Then one fine morning after deep slumber, they come to a conclusion. This
Mr. Alukush is appearing for the corporation.
similar
Is coming.
plan sanction right crystallized, not permitting us, my lord, to do construction because as per their version it is heritage, and heritage commission is clear this is not a heritage property. Heritage commission is there, my lord. Corporation heritage conservation committee is also there. Experts are there, including corporation people in heritage commission. They are of the opinion this is not a heritage property. This property can be reconstructed, can be, my lord, the redeveloped and all these things. But the KMC is standing on the way in spite of granting sanction building plan in lieu of a, my lord, lump sum amount to their credit. This is our difficulty, my lord.
Next week?
Next Thursday.
Yes, my lord. A line order may kindly be recorded.
Learned counsel for the proxy counsel for the respondent states, learned proxy counsel for the respondent states that the main arguing counsel, Mr. Arup Ghosh, is busy in another court. He requests for a short adjournment. Let this matter be listed for hearing on
Let it be retained in its position.
next week, 14th.
But this is my application. Not here, the problem is this, the petitioner is the owner of a property. The property has been assigned by the corporation or as the property tax has been issued by the corporation at page 39. Your lordship kindly come. Corporation.
Yes.
As Tika property. Represented by the controller Tika tenancy and owner of the structure Lazy Boshnath Simali.
It's a Thika property. Thika property.
It is the assessment of the corporation.
Yes.
There was the intending purchaser of the property who made the application under Right to Information Act. And that under the Right to Information Act, the Thika controller has indicated, has informed, page 38.
Subject and it's 41, 57, 60. Yes.
Only miscase has been filed by the tenant of the land in question. Nothing more, nothing else. No final decision has been made. Now, as per the Thika Controller Act 2001, unless the determination is made by the Thika Controller, the land cannot be denoted as the Thika land. It is known to everybody. I need not elaborate. I did not make any further submission on that.
Who are you? Who are you? Are the?
I am the owner of the land. I received the land along with my brother from my father and mother. I have described the description of the property in my read petition, paragraph 1 to 5. My father granted a lease. Lease was expired. The Bojanath Simali was refused to hand it over. Then he filed this application. I am only praying, your lordship kindly.
Their name, appropriate application to be made before the authority to mutate their name. They have not made any application.
How can I? Unless they cancel this thing. Unless they cancel this thing.
As claim as a owner, he has to prove that.
Unless they cancel it, this is owned by this. How can they write it? What is their document? May I put this question to myself? Even if I make the application on my own, they will reject it, that this land belongs to Thika. What my learned man is saying, I don't know. Let him make submission that if I make the application, they will accept it and they will proceed in accordance with law.
You consider his application.
Then
My seniors, let me make one submission. They have prayed for consideration of the representation in their prayer.
Yes.
They have already made a representation. Let it be considered in accordance with law, giving them a hearing.
Yes.
But what is the representation? For amendment of the assessment book.
Do you want the representation to be decided, or you want them to?
I made a complaint to them.
Yes.
The prayer was for amending the same.
Yes.
But the amendment has not been done. That's why I have come here.
All right. So let them file their affidavit in opposition. We will consider that. You file your reply.
Or may your lordship may direct them to consider them and to produce the document before your lordship, so that your lordship may go through it and may pass appropriate order.
Let them file their reply.
Then, my lord, this year this cannot be done.
This year, no, this might take 5 years. You
Yes.
never know.
Then, my lord, your lordship, can you direct them to consider the same? I shall come back again.
Up to you. The petitioner has
Clear, clear.
preferred the present writ petition, seeking a direction upon the respondent municipality, respondent corporation, to amend or rectify the
Yes, yes.
assessment.
I'm sorry. I forget that my prayer was there.
Yes.
I'm sorry, my lord. Because this matter was written prior to the summer holidays, and totally I forget it.
You don't read your brief when you come here.
No. I have read it. See, last week I read it because last week
Not the last time you read it.
No. Last week I was the impression it will be taken up because there was a resolution from the bar. If nobody is present, matter can be taken up. I have seen in my experience the later order matter is taken up on that date when the earlier order matters advocates are not present.
No, but we did a lot of matters.
But I have seen in your lordship's court up to 26 everybody was present, and 11 was continuing Mr. Banerjee's. And then your lordship is to release the matter after 2 p.m.
Because we had a specially fixed.
I have seen
Which
all along. This is my maiden appearance, your lordship. All along I am here. I was there on the last week. I have seen from the morning whether I can get my chance or not. But this week I cannot get any time for other matters. I thought it that I have prepared myself. That's the overconfident.
क्या लिखवाया? Amend the assessment register in respect of the property situated at 57/6A, B full stop T capital A dot road, PS Sinthi, Kolkata, by recording the petitioner's name as the owner thereof and to carry out the mutation in his favor. The case of the petitioner is that he inherited the said property from his ancestors, full stop. During his lifetime, the petitioner's father had granted lease in favor of one Bajnath Shimali, father of
He is the father of respondent number 6.
6. That's what I'm writing.
Respondent number 6, yes.
Here the order, sir. During his lifetime, the petitioner's father had granted a lease in favor of one Bajnath Shimali, bracket mein father of respondent number 6 for a period of 20 years. Full stop, bracket close. Bracket close, full stop. The said lease was terminated in the year 1980.
Yes.
Whereupon the property was peacefully handed over to the petitioner's mother. Full stop. The petitioner states that physical possession of the property continues to remain with him. Full stop. The petitioner subsequently came to know that, notwithstanding the return of possession, the said Bajnath Shimali submitted a return in form A inverted comma capital A, deposited the ad hoc rent, and also initiated proceeding being Miss Case number 41 of 2016 under the West Bengal Thika Tenancy Acquisition and Requisition Act 2001, which is presently pending adjudication. It is the specific case of the petitioner that the said property does not fall within the definition of Thika tenancy, and the ownership of the structure is shown as ownership of this does not fall Thika tenancy, full stop. Uske baad aggrieved by such erroneous entries, the petitioner submitted a representation. What is the date of your representation?
When a representation dated,
Page number 40.
representation is 4th March 2025.
The petitioner submitted a representation dated 4th March 2025 to the respondent corporation, seeking necessary correction, full stop. However, no action has been taken till date on his representation. Full stop. Learned counsel for the respondent corporation submits that the authorities are ready and willing to consider petitioner's representation dated 4th of March 2025. Full stop.
Giving hearing to them.
Representation. Learned counsel for the petitioner states that he shall be satisfied if the same is done within a time-bound manner. Full stop. In view of the statement made by the counsel for the parties, the court directs respondent number 2 to decide petitioner's representation dated 4th of March 2025 within a period of 6 weeks. Within a period of 6 weeks.
For 6 weeks, puja vacation will intervene from today.
For them, puja vacation is not 1 month. That is only our prerogative.
No. It appears that for us it is declared 1 month. And for corporation and government it is undeclared. Declared 15 days, undeclared another 15 days.
We'll go by the undeclared one. Respondent number 2 to decide petitioner's representation dated 4th of March 2025 within a period of 6 weeks from the date of communication of this order, strictly in accordance with law, after affording an opportunity of personal hearing to the petitioner as well as any other stakeholder. Have you made them party?
Yes.
Private respondent.
Or
Private
petitioner
respondent or any other stakeholder.
or his authorized representative.
Personal hearing to the petitioner or his authorized representative. By way of a speaking order, full stop. With the above direction, the present petition is disposed of. No affidavits have been called for. None of the contentions are admitted. Particular paragraph. किसी order से. Since no affidavits have been called for, none of the contentions are admitted by the parties. That's it.
Corporation. পয়সা অনেক বেশি হয়ে গেছে।
Grateful, my lord.
ট্যাক্স দেবো না।
There needs to be an amendment in the cost title because my client's name has been wrongly incorporated, my lord, and for that, my lord, he could not receive the copy. But,
Who's for the petitioner? Who's for the petitioner?
no one is appearing, my lord. No one will appear because let me tell you, my lordship, my lord. On an earlier occasion, there was a appeal matter before the my lord Justice, Chief Justice, my lord, where the same issue has been carried on, my lord, the sanction regarding an unauthorized construction, my lord. Sanction plan is there, my lord. My lord, the Chief Justice has considered that and disposed of the, my lord, dismissed the PIL matter, my lord. Same issue, perhaps, my lord, has been taken over, my lord, before your lordship.
None for the petitioner, dismiss and defer.
Great.
Lordship, Lordship, in item number 17, due to some personal inconvenience of the learned counsel.
Sorry?
Due to some personal inconvenience of the learned counsel, Mr. Kasimuddin, I'm praying for not this week, Lordship.
Proxy counsel so and so appears and states that the main arguing counsel is indisposed. She prays for a short adjournment. Let this matter be adjourned to 28th of August. 28th August.
Mine.
Item number 18, Lordship, I have instruction to appear in this matter, Lordship. Kindly. আমাকে appear করতে বলেছে KMC।
Time Oh. My lord, I am for the petitioner. Lord, the private respondent, my lord, in garb of renovation of an existing 3-storied building, now the entire building is demolished and the new construction raised. My lord, why this writ petition, my lord? Number one, my lord, this building is erected just adjacent to the Thakurbari, the birthplace of Rabindranath Tagore. That building is declared as heritage. And my lord, the permission from Heritage Commission is required to erect any building nearby any heritage site. And there is no heritage permission
Mr.
number one.
Dalpati, have you made a representation?
Yes, my lord, page 16.
Page
16, 1-6.
Yes, consider his representation.
I am filing a report, my lord,
Report, who are you?
police report.
What do you have to do with unauthorized construction? What is your
No unauthorized construction.
no unauthorized construction? Who are you to say that? Since when the police has assumed the role of KMC?
Yes. He has investigated the matter, inquired the matter.
Your duty is only to ensure that when a work stop notice is issued, you comply with that. Nothing more.
Lordship, kindly keep it on next occasion, Lordship. I shall file the report. I have no copy right
Yes,
now.
your lordship can grant time, but
Take
in the
instruction.
meantime, no
You can-
construction to be.
Lordship,
You take instruction. We'll keep it next
Okay,
week.
Lordship.
Take instruction.
yes, Lordship.
Give a copy, Mr. Dalpati.
Yeah.
আমাকে একটা দে।
Where did he go? Where did that person go? The state lawyer, yes.
I'm happy.
What are you saying? What is your report?
Yes, my lord.
What is your report? Your report is no unauthorized construction.
No unauthorized.
Read the report again. You are saying that you have sent a communication to the Calcutta Municipal Corporation asking them whether there is a sanction plan or not. How can you say non-authorized construction? Where does your report say that? Read your report. Give a copy. Read it. Read the whole report now.
Sorry, বলে এই তো লিখেছে however till date no report regarding illegal.
Let me
How
educate
it
you
is
now.
unauthorized?
No, read it. Read it. Read in this context. Read the second paragraph, third paragraph.
এই প্যারাগ্রাফ এই জজ
Let
সাহেব
me see your understanding of your own report.
Carried out.
Hmm.
And to be
সেটা কি করে বলেছে?
সরি বলে না।
How can you conclude?
unconditional apology, my lord. It is not a clear.
All. Okay.
But from the report, it reveals that the construction work is continued.
Keep the report next week,
Lordship.
14th. Not today, 14th.
14.
Okay, my
Take
lord.
down, learned counsel for the
14.
petitioner. Take down. The petitioner has filed the present writ petition challenge, seeking inaction, alleging inaction on part of the respondent corporation in not stopping the unlawful, illegal and unauthorized construction being carried out at 12B Madan Chatterjee Lane, Ward number 41, Borough 5, Calcutta. On behalf of the private respondents. Respondent or respondents? One
Respondent.
respondent on behalf of the private respondent. Full stop. Learned counsel for the petitioner submits that the said construction is being carried out without any valid sanction plan. Full stop. He further submits that. Are you sure about the heritage?
Yes, my lord. Jorasako Thakurbadi is just adjacent to this site.
He further states that this property is situated close to Jorasako Thakurbari, which is a heritage property, and any construction within the vicinity shall have the permission from the Heritage Commission. for raising any construction. Full stop. Learned counsel for the respondent corporation seeks time to take instruction. Let this matter be listed on 14th. We can decide, we can dispose of the representation, take instruction to that effect.
Grateful, Lordship.
Or by virtue of the sanction plan, G+4 storage building has been constructed. Now there are certain deviation in respect of that construction. I made an application for regularization of such minor instruction in terms of 2015 rules. Immediately after receiving the same, the person or some persons of the corporation came to my house and threatened that I have to demolish that unauthorized construction or they have to take. This is the crux of the matter. Now my representation has page 246. By virtue of the 2015 regulation, the KMC has the authority to make such regulation upon making of such fees. Now, point at the time of hearing, point has been cropped up, raised by the corporation advocate Mr. Ghosh, that unless a demolition notice under 401 is issued to me, then question of consideration of regulation does not come. This is the issue. Now, whether service of notice for demolition is precondition for consideration of my regularization, it is the point. Now, on the similar set of facts in respect of the Town and County Planning Act, this Honorable Court held that it is not the precondition for consideration of my representation for regular. They can dispose of or they can reject it. Thereafter, proceedings can be done. Or may I hand over the ratio of their judgment first? Thereafter, Honorable Supreme Court also, in respect of the one of the matters, held that regularization can be done in respect of the tenant also, not the owner itself. Tenant also can make that up to that extent. Honorable Supreme Court held. I am placing that first judgment of Justice Chondo. This is in respect of the Town and County Planning Act, and this is in respect of KMC Act. But ratio has been decided whether it is precondition or not. But kindly seize that paragraph.
Where is Mr. Ghosh? You are doing it?
Internal page 14. I have handed over my copy or folding page or not, I am not sure, but I page 14, paragraph 27 onwards. This issue has been dealt with. In respect of section 53, that regulate the unauthorized development, kindly seize this paragraph 27, 28, 29. And Honorable Court held it is not a precondition for issuance of notice itself. They can alone decided the issue for regularization. Either reject or কপি আমি দিচ্ছি, তুমি লিখে নাও দাদা। এটা 15,581 851 24 paragraph 28, it is defeating the object regarding I oblige to your lordship. Now, Honorable Supreme Court, just it is the latest, I cannot say it is a judgment, but 2024 SCC Online Supreme Court 2918. So let them consider in the touchstone of my whether it is permissible limit of regularization or not. They have to take a decision to that effect. Not kindly seize short order, I believe, but it is on upon service of notice also in respect paragraph 3 onwards.
আপনারা ছিলেন, আমি তো ছিলাম না।
আগের দিন যেটা হয়েছিল সেটা তো কি বলছে?
So,
Regular
subject to
entity.
correction, let them take a decision first. Either reject, or if it is not within the permissible limit, they can issue a notice for demolition in terms of 400 onwards.
Yes.
My lord, matter has been considered, my lord. After inspection of the building, there was another heavy unauthorized construction, and we have served notice under section 401 to stop the work. And my lord, thereafter, we have sent the matter before the authority to take action under what provisions they will prefer. It may be 401, it may be 408. But we have no instruction till today that they have taken any decision that the matter has been placed before the higher authority for 408 or 401. That is not in our knowledge. Now, when the message unauthorized construction, now, my lord, we have to take decision. This is the position. And my lord,
But he's seeking something else, sir. He's saying you
unauthorized
consider
construction,
his.
but actually the unauthorized construction in this fashion, that
Sir,
they have
who-
blocked the entire, the side open space, rear open space, and front open space. Making, this is the position. My lord is no.
Sir, I am saying, why don't you consider his regulation application, dismiss it, reject it? What is the difficulty?
My lord, under section 400 subsection 8, there is no scope for any hearing or anything. Whether there
That's a
is,
separate proceeding, madam. Today, he is not challenging your demolition notice.
my lord,
He
when
is here asking for regularization under your scheme.
under my scheme, under section 400.
Yes,
But it is under 400 subsection 1 where a regularization provision is there.
yes.
That is a minor construction regularization provision is
So you
there.
decide it is not
My lord,
minor.
but I am on, my lord. It is the discretion of the authorities to decide whether the unauthorized construction detected would be dealt under subsection 1 or subsection 8 or section 400, my lord.
That's all right.
Under subsection 408, if a decision is taken, then there
Madam,
is no scope for
408
considering his representation.
408 is an emergent provision to be invoked only when you see that it is something which is necessary and immediately it has to be done. 408 is not something which you invoke anytime and any way you want to.
My lord,
Every
this is an
individual,
under construction building and they have encroached every site space and they have
you
even
demolish it. That doesn't matter. Whether the application can be considered or not, you can consider the application and reject it.
then, my lord, it will be a provision of subsection 1, my lord. Then I have to give a hearing then.
You, as
According
it
to
is,
them.
madam, you have to give them a hearing unless and until it is an emergent necessary provision of 408. Mr. Ghosh is here. Mr. Ghosh,
My lord.
they are seeking a regulation application.
My lord.
Regularization. Their regulation might not be possible also, but why don't you consider it?
But I'm submitting to your lordship, there is a judgment of the apex court.
Yes.
My lord, on the last occasion I submitted
Yes.
that there is no provision for regularization in the act itself.
Mr. Ghosh, see this judgment. Give it to
রাজকুমারী দেবী সিং
হ্যাঁ?
রাজকুমারী দেবী সিং যেটা
Yeah.
রাজকুমারী এইটা ওই একটা কেস পার্টিকুলার এখানে বলেছিল না টেনেন্টস উড বি গিভেন আ চান্স টু মেক অ্যান অ্যাপ্লিকেশন
কোথায়?
ওটা দিয়েছিলাম আমি আগের দিন। হ্যাঁ।
Well, this category is not an order in a particular case. The Supreme Court may pass such an order. But Supreme
They
Court
have-
has, my lord, in
They have passed an order only when you have a scheme there.
no, there's no scheme. But a scheme, had there been a scheme for regularization, I could have accepted.
They are saying the appellant is seeking limited prayer.
That is, my lord, that is
Just
the.
a minute.
I'm sorry, my lord.
Just a minute. Regulation of the premises subject matter of this appeal under the provision of Calcutta Municipal Corporation, Regulation of Building Regulation 2015.
That regulation, I tell your lordship, you should consider, my lord. The Supreme Court may say that because Supreme Court could, my lord, pass such an order because the issue has not been decided there. Main issue has not been. Somebody has said that I have a limited prayer. I am going to the Calcutta Municipal Corporation for regularization. That, my lord, court, my lord, may pass such an order for direction. If that such a direction of the Supreme Court, I am to accept it. But the thing is this, my lord, when the matter in a, the court, the High Court for another 226, usually see where there is a provision for that. If there is no provision, my lord, in my submission,
Just show me the regulation of building regulation 2015.
2015 আছে তোমার কাছে? Usually, first of all, you see, my lord, before looking at that regulation, section 400 subsection 3.
All I need to do is follow the Supreme Court. I don't need to do anything.
No, Supreme Court regulation, Supreme Court, my lord, passes an order and
What to do,
141,
sir?
142, your lordship knows, my lord.
What to do? We are bound by the
Your
Supreme
lordship, my
Court.
lord, of course, my lordship could say that 141, 142, your
Mr.
lordship knows.
Ghosh,
Well, lawyer, the Supreme Court has
Mr.
decided the
Ghosh,
issue here.
is the High Court bound by the Supreme Court
Supreme
judgment?
Court bound, my lord, where the law has been decided, the issue has been decided. Your lordship, of course, my lord, bound by the High
Why-
Court, also, so also I am.
Go and test
I
it.
am also, my lord, I am also bound by the Supreme Court order.
Yes.
But you logically appreciate that Supreme Court has said the order which the ratio has been decided on concept of law, that will be binding, but not otherwise. But Supreme Court is supreme. Supreme Court said that Supreme Court says, well, I have read in one judgment that we may, for the purpose of effective the relief for consideration of anything, we may pass such an order, but we are not always right.
Mr. Banerjee, only Mr. Ghosh can make the statement.
Now, I'll show you a judgment to your
Only
lordship.
Mr. Ghosh can make the statement. Supreme Court is supreme.
No, Supreme Court itself has said so. Supreme Court has said itself that we may not pass such an order which may not be correct all the time. Supreme Court has said, I have read the judgment. And that since Supreme Court has said, but it is our order which is to be obeyed because there is none on our head. Since there is none on our head, this is the Supreme Court view. And Supreme Court itself said that we are not all the time correct. Of course not correct, but because there's sometimes, my lord, for my lord, the clients, my lord,
I wish.
I told you, Lordship, Lord, there are two ways of approaching a problem. One is to the right, to the left. Here, Mr. Ghosh will approach it both through the right and left.
No, Supreme Court, my lord, of course, my lord, but here these ratios were decided, I'm telling you, Lordship, my lord. And I have shown, I'll be showing to you, Lordship, my lord, one judgment today is not with me. But there the Supreme Court said, unless the provisions, my lord, said so, for consideration of any
When do you
representation,
want it, Mr.
Hello?
Ghosh? Next week. When do you?
next to you, Lordship. Because in another case, I've kept the judgment with
Mr.
my my lord,
Ghosh,
press.
you bring all the judgments, whatever you have to.
Well, only, oh, my lord, one judge, yes, my lord, one judgment is with me. I'm just placing it. Other side.
If you are prepared, then we'll decide the issue.
Well, just a one paragraph.
If you
I'm
want
showing to you.
time, we'll have it next week. Whatever you want. I'm ready for both. What do you want? Mr. Ghosh,
My lord.
what do you want? You want to argue today? You want to take time? What do you want?
The next day, you'll see me fix another day. Because, my lord, it will be an issue, my lord, if a lordship passes an order.
That's why I'm saying, I want to
Therefore,
hear
my lord,
you,
because
then
it's
pass
not,
an order.
it's a case will be not an isolated one in one case.
That's what I'm saying,
Right.
Mr. Ghosh. That's why I'm giving you time so that we pass a order which is not an isolated, then it will be applied in all other cases.
In all other cases, it will go on. That is the reason I'm submitting.
That's why I'm not passing an order. That's why I'm asking you, when do you want it?
My lord, and 28 your second.
28th.
Alright, before parting, kindly cease.
You bring all your judgments that day,
Yes,
sir.
yes.
You
No, no,
take it
this
back,
is in
we-
respect of the submission. Our High Court also same passes the same order. Kindly cease 1 minute. I am just 1 minute. He says 408 notice was issued. Therefore, it cannot be considered. Mane this is Sina held. Prior to holding any decision for 408, my application for regulation to be considered. Thereafter, it is to be proceeded.
There are different judgments, different orders from the
I have
different
also
benches.
passed orders where I have held 408 to be right,
That is there, but it is to be considered.
depending
first.
on the situation and circumstances.
My lord.
Not today. Just keep it after 28th.
Any order is
Why? You're a private person.
I will
At the request of the parties, let this matter be listed
Yes.
on 20th.
for our purpose.
You are not appearing for corporation.
No,
Your
I am
bill
not.
gets cleared only on your appearance.
Sometime my lord, my client wants. If there is no order,
Change your client.
It happens, my lord. And now live streaming is going on. Each and every client is, my lord, watching this. And prior to us.
That is transparency.
That is transparency. Obliged to your lordship.
Yes. Next.
But this is an issue of wide amplitude. That is the reason why want to point out.
Yes, it will. It will. You're right. That I agree. It will have wide.
Yes, well, that is the reason.
Yes. You are absolutely right. Tomorrow you will be flooded with these applications. Tomorrow you'll be flooded with these applications.
That is the reason, my lord, my endeavor would be, my lord, to satisfy your lordship on that.
KMC is a bundle of contradiction. My lord,
No,
their ambiguity.
That may be at our end.
Hot and
That may
cold.
be at our end, but not at the end of the judiciary.
We should be very
Talking
clear.
about.
Your end.
Yes.
Carry on. My lord, what happened, my lord, on 18th June, there was an order. My lord, it is my failure, my lord, to undertake necessary correction.
Yes.
My lord, I am praying, my lord, lordship, time may kindly be extended to incorporate name of the tenant. It's a dilapidated building to be collapsed at any point of time. We pray for 412A application. Lordship was kind enough to direct us. One or two tenants' name was left out in the cause title. Their name is required to be recorded. My lord, that direction was there, my lord. My lord, there was some delay because client was unwell. We are not
Counsel for the petitioner
lordship.
seeks further time to add tenant/occupier of the relevant building as respondents in this writ petition. Full stop.
Today itself we can undertake
Counsel
correction.
for the petitioner seeks and is granted further time of
Within today itself, if lordship kindly permit,
further
within the
2 weeks time to
date may kindly be fixed.
add tenants and occupiers of the relevant building as party respondent in the present. Let this matter be listed on, when do you want?
Yes, 28th, my lord.
28th.
Allow us to undertake necessary correction, my lord. Over here.
Necessary correction can be carried out. Necessary correction shall be carried out.
Deeply. এই ফাইলটা একটু দেবেন বলছি ফাইলটা একটু দেবেন কারেকশনটা করে নিন
But you have to serve them.
Yes,
After adding them, you have to serve them also.
yes, correction, and then I will take necessary steps. All details are with us.
But I appear for KMC lordship.
Yes.
I'm for the petition. I'm virtually connected, my lord.
My lord, this is a matter, my lord, where unauthorized construction was alleged.
So the unauthorized construction has been held over a plot, and where I am the adjacent owner, and I made a complaint before the corporation KMC authority. Initially, the KMC authority doesn't look into this matter, and thereafter I was compelled to file a writ petition before this honorable court. In the month of January, when the matter was decided by His Lordship Justice Chanda, we came to know that there is unauthorized construction has been detected by the corporation authority, and they have passed an order of the demolition. The order was subsequently challenged before the learned tribunal. But in the learned tribunal, they got no stay to over the said execution of the demolition order. And for that reason, I have filed an application before the KMC authority to demolish the said illegal and unauthorized construction. Entire building is unauthorized. Entire building is unauthorized. And that representation has not been considered. Nothing has passed, no order has passed in respect of my application. And the tribunal.
You had filed another writ petition also, sir. Seeking.
Yes, earlier.
Where is that order? That has the same.
Well, that order.
You
I
have
had
filed this
annexed in the
petition
case.
on the same self cause of action.
No, my lord. At that time, when I filed this writ petition, we were not aware that the entire construction is illegal, but subsequently came to know that the entire construction is illegal.
All right. Show me the first order. Show me the second order. Show me the order.
Well, the first order is at page number 49 onwards.
This is the first order, right?
Yes, this is
the
the
second
only order. Only thereafter, if went to the tribunal, I have checked up that there is no stay granted by the learned tribunal.
The first writ petition was WPA, which one was that? The first one?
What was there's the order, my lord has seen 883 of 2024. Page number 49.
It's pending, it's still pending. No writ petition.
Yes, Mr. Naik.
So, my lord, this order speaks about, my lord, what stands to be taken of by the KMC. Now, my lord, since, my lord, it is pending, and, my lord, entire file was called for, so entire file is with the tribunal. That's to be complied with. This is the situation. In such view of the matter, my lord, how we are hesitant whether it will.
Why there is no stay? You can go ahead with the demolition.
That is, my lord, obviously, my lord's interpretation. That is a, my lord, standard interpretation.
That's
But
right.
whole thing is this: when statute will not provide some remedy,
That's
and
what the
matter is for
statute
the
provides
statute.
remedy, but statute also provide order to be passed in favor of somebody.
May I humbly, my lord, make a prayer before lordship?
Yes.
Give us some direction, given the time bound. If it is not done, then so that we can proceed.
With the
At least,
honorable
my lord,
division bench
some-
in another matter, in
some-
WPA 101 of 2000, were decided that if there is no stay,
No,
then
that
the
is always, that is
corporation
standard, my
can
lord, that
demolish
is our
this one.
argument always in any matter. No doubt about it, but we have to respect, my lord, the higher forums, not the high, this is the constitutional bench. Therefore, if any observation comes from this honorable bench, then, my lord, I believe, my lord, that will be much more helpful for.
No, but you take a decision when will you want to demolish the building? You have already passed the demolition order.
That's the, my lord, I believe, my lord, allow 3 months time for either of the parties. If there is no change, stay order or anything, then, my lord, we have to proceed.
There is no stay order. That's what you are for the private.
State one. What is for the
There is stay.
Have 10 questions.
You are for state. State, I don't want. Who is the private respondent? None for the private respondent.
None.
Or alternatively, lordship may be kind enough to ask a petitioner to serve once again a notice after a week, because private respondent should also know what is happening. Should also.
Where is the service? Affidavit of service?
Well, affidavit of service is before filing, affidavit of service is given.
How it was served, right? Private respondent.
Private respondents who are carrying out the construction is Sujay Kumar Das.
Yes, my lord. The two persons are there. One is Mr. Ganesh Banda, another is Mr. Sujay Kumar Das. Respond number 8 and 9.
In support or contention, would your lordship be kind enough to permit us
Just
to
a minute,
file one
yes.
report? What it is, person responsible, two persons there. It is. Suitcase to file you to carry it.
Yes, what are you saying?
Lord, one report we are receiving, though it is not in the form of affidavit, if my lord can allow us, we can put it on record. Obliged to lordship.
The petitioner has preferred the present writ petition, being aggrieved by the inaction of the respondent corporation in failing to implement its own demolition order dated 23/9/2023 in respect of premises number 7/1B, Rai Charan Paul Lane, Police Station, Topsia, Calcutta, under ward number 59, Borough 7. Borough 7 of Calcutta Municipal Corporation. Full stop. This is the second round of litigation. The petitioner had earlier filed WPO number 883 of 2024, alleging unauthorized construction on the said premises, full stop. This court-wide order dated 22nd January 2025, comma, disposed of the said writ petition, comma, noting that the respondent corporation has already passed a demolition order dated 23rd September 2023, comma,
My lord,
that
it should be 2024. Actually, it was a typological error. It was
the order is
2024.
23rd September 2023, sir.
No, but I have checked it up. It is
So
2024. my lord.
why didn't you change the order? I can't change the order. Sorry.
My lord, whatever, my lord.
23rd September 2023, comma, and that the private respondent had preferred an appeal, comma, being BT appeal number 90 of 2024, comma, before the building tribunal, full stop. This court had further granted opportunity to the petitioner to file appropriate application before the building tribunal to ventilate its grievances, if any.
6 months we get 6 we have to stick to both.
Have you filed any application before the
So,
building
yes, my
tribunal?
lord. Yes, my lord. We filed an application because but the London Tribunal has not granted any stay upon the application made by the appellant.
Have you
Yes, sir.
filed any application before
Yes, my lord. I made an application for adding up the parties.
of adding up the parties? All right.
Parties.
Most
It
of
is-
copy has been sought.
It is the petitioner's submission that he has already filed such an application in the pending appeal before the municipal building tribunal, full stop. However, no interim order of stay had been granted by the, he further states that no order of stay had been granted to the private respondent before the building tribunal, full stop. The petitioner has once again approached this court seeking implementation of the demolition order dated 23rd of September 2023, full stop. This court has heard the counsel for the petitioner and has perused the materials on record. This court had in WPA number 883 of 2024 already observed that in view of the pendency of the appeal before the municipal building tribunal, comma, it was not inclined to entertain the writ petition seeking demolition of the subject structure, full stop. The mere absence of stay does not render the क्या लिखा है फिर से एक बताना does not render the demolition order inexecutable. उसको काट दो इसको ऐसे कर दो फिर this court the present writ petition is disposed of with a request to the municipal building tribunal to consider and dispose of BT appeal number. What is the BT appeal number?
BT appeal number 90 of 2024.
MBT
90 of 2024, my lord.
My lord, this is I've annexed, my lord, the notice. MBT numbered.
But then
generally 90 of 2024.
How many matters are listed, Mr. Naik? You go to the tribunal. Are there a lot of work? In the tribunal, there are a lot of matters listed here.
Yes.
Yes. Work pressure.
Yes.
Lot of work pressure. All right. I'll change it. Then just write it. The learned counsel for the respondent seeks and is granted 3 weeks time to file a report by way of an affidavit. reply to the exception to the same, if any within 1 week, list after 6 weeks, give it after 4th of, sorry, 6th of November. 6th November,
4th of Lordship.
6th of November, 6th.
Extremely grateful, Lordship.
The report filed by the state is kept on record.
Grateful, my lord.
Mr. Nayak, take action. Nobody is stopping you from taking.
My lord, this is now, my lord, the regular crisis, regular problem of Calcutta. And my lord, is also, my lord, I am not here to apprise anything because we are enlightened.
Now I'm
There will be number of matters. Number of matters. So, my lord, this is a regular feature. And, my lord, we are surviving. We are trying to, my lord, be survived. Grateful, Lordship.
I don't want to burden the tribunal. That's why I didn't pass that order.
Your Lordship, this is my application. In fact, on the last occasion, we had filed this application bereft of the pictures. Your Lordship was very kind to grant us leave to withdraw it and file it afresh. Lordship, the short circumspection in this application is that, Your Lordship, I appear on behalf of the Traders Association in Bara Bazar. Your Lordship, if I can just draw a parameter or a visual image in your Lordship's mind, this area Bara Bazar is, if I can take your Lordships back to the streets of Lajpat Nagar, when I take a left from the Natural Ice Cream. So certain structures in the name of beautification were created right outside these shop rooms. I had made representations, I had filed a prior writ petition. Her Ladyship Justice Amrita Sinha had heard that writ petition, directed the KMC officials to consider my representation, and also had taken note of the impediments and embargoes that the creation of such structures would proffer to the shop owners. Against that, we'd made representations before the KMC. The KMC tells us that you go before the Parks and Squares Department. We make a representation before the Parks and Squares Department. There's no rejection as such. There's the administrative inertia. There's no reply. No action taken. I'll just take your Lordship to the relevant pages of the writ petition. Your Lordship can adjudicate. Your Lordship, if I can directly take your Lordship to the
You have
order
made them a party.
Yes, your Lordship, they are a party. This indicate to your Lordship, respond number
The Parks and Square Department.
Your Lordship, respond number 4. In any event, your Lordship, if I may submit with the greatest of respect, I need not, because by dint of the provisions of the KMC Act, it is the corporation.
Bara Bazar. Where is Bara Bazar?
Bara Bazar, your Lordship, it's in, I'm guessing, it's in North Calcutta. Very, very close. Central Kolkata. It's a packed area. Your Lordship, if I may just take your Lordship directly to Justice Sinha's order, page number 16, if your Lordship is kind enough to come to once.
Yes.
It's 23 to last. Lordship, that's the order. If I may just take your Lordships through the relevant portion, page number 21. It appears, because your Lordship, of course, the aim of the corporation is it's in the subterfuge of beautifying the streets. So the second paragraph, it's not numbered. It's the inceptive portion is it appears. It appears that if your Lordship is with me,
yes.
It appears that though the aim of the corporation
You're
is
reading
to
the order. You're reading the order.
The order. If your Lordship so desires, I'll place it right from the inception. So then your Lordship would just be abreast of the facts in the backdrop of which this writ petition was proper. So your Lordship, this is on the footpath. So the ability of pedestrians to ply is also restricted. And that is reflected in Her Ladyship's order in page number 22. And subsequently, the operative portion in page number 23, the second paragraph. The Lordship is with me, I'll place the relevant portion.
Yes.
Your Lordship has already perused the order, so I need not embellish your Lordship's wisdom in that regard. This writ petition, in effect, is an implementation of that order. Your Lordship will subsequently see page 25 by a letter dated 11th of June 2024. I have made a representation before the corporation for removal of these structures. Page number 25. Subsequently, they remit to us and they respond to us that this representation ought to be made before the Parks and Square Department, which your Lordship will find at page 28. Accordingly, your Lordship, we've made a representation before the Parks and Squares Department, which your Lordship will find on page 31. Your Lordship, this is the material aspect. Now, in a rather arcane manner, your Lordship, this representation has been given a go by. I have proffered the particulars of the shop rooms on page 34 as per your Lordship's large direction when I filed this writ petition. And the pictures, your Lordship, if I can showcase to your Lordship, page number 42 onwards. No. 41, your Lordship, your Lordship had granted us leave to file this writ petition afresh. In terms of that, page 42 have come up with the pictures. Your Lordship will see it is right in front of the shop rooms. Your Lordship, the practical embargo, if I may espouse your Lordship, these streets on weekdays or weekends now, especially with the pujas coming, it's packed, your Lordship. So there is a inhibition for the pedestrians to ply on the footpaths of these streets. And your Lordship, one more aspect, if I may show, which is rather material. In fact, I'll take your Lordship to the Hindi newspaper cutting, page number 39. Lordship, for reasons of propriety, let me not read it out. For the inceptive portion, I will.
Who appears for respondent 4?
Hello?
Four.
Yes,
You're
number 4.
Obviously, you will be appearing, Mr. Ghosh.
The Parks and Square Department. Well, that the judgment which my Lord is pointing out the Honorable Justice Amrita Sinha, they are really, my Lord, we did certain works on the footpath. And on that issue, they came to the court, my Lord, that creating problems. And whatever the directions, I don't know, my Lord, I hope, my Lord, that has been removed.
No, it has not been removed. That's why
If it is not removed, it is to be removed. But for that reason, my Lord, you ought not to have come with a separate DT application. You could have prepared an application before the Honorable Judge which passed the order. Of course, when it is a duty that it is to be removed when the order is there. So far as that is concerned, but what he is asking for, that you logically see this there, but that order has to be complied with because that order was there and I made my submissions whatever way I could. Now he is in this petition submit manner, response number 4 to take steps to demolish and clear the encroachment of the footpath blocked by the respondents forthwith. But these respondents, who are the respondents, I don't know. So far as the respondents, so far as that part is concerned, for beautification, what has been construction was done by the Kolkata Municipal Corporation, directed to be removed by the court, my lord. In terms of the order of my lord, Mr. Sinha, it is to be well completed. There is no issue at all. If my lord may say that the order which my learned friend, my lord, Mr.
So I'll
Sinha has
record,
passed,
I'll record your submission that you will,
and my lord, I may take
will
my,
comply
I
by
may
the
assist
order
you.
and file a report.
Yes, of course, my lord, because I cannot say anything otherwise, because when the order has already been passed by the court,
Very good.
not appeal from that, that order has been meticulously to be followed.
All right. We will pass a direction. They will comply with the order passed by Justice Sinha.
Justice Sinha.
Yes,
And
Your
they'll
Lordship, but
file, they'll file a
subsequently
report
not
within
under the subterfuge that this decision is to be complied by the corporation or the Parks and Squares department of the corporation.
whatever
which
it
is
is,
an
he appears.
interdepartmental rigmarole.
No,
that
that
we are
is not
operating.
required, because it's a corporation function, whatever the department
Where are
is
the
done.
direction in the order?
Your Lordship, I'll just take Your Lordship, because Your Lordship, the order essentially states that a decision will be taken by the department in this regard. Page 23, if Your Lordship takes the last portion, a decision shall be taken in the matter at the earliest, but positively within 8 weeks from the date of communication of the order. Just prior to that, the corporation and the police shall ensure that no business from the footpath is being run. That, Your Lordship, is a difference, because we are the shop owners of brick and mortar shop rooms.
কি বললেন? তাহলে কি আছে? তুমি
সেজন্য তো আমি রেসপন্ডেন্টকে লিখেছি।
পরে কাছে যাও কেন?
তুমি বুঝেছি, হ্যাঁ। Your Lordship, the direction is incumbent upon the respondent. But to come under the subterfuge and saying that and proffer an interdepartmental rigmarole that the Parks and Squares, because Your Lordship, I'll place the provisions of the Kolkata Municipal Civil Act.
Let them decide. Respond number 4. I'll give a direction. Let them take a decision on this.
On respond number 4, Your Lordship, because I'll just
Respond number 4 is the Park and Square Department. That's what they're
Your
saying.
Lordship, but otherwise, if I may just place one.
That is a department under them.
It is a department under them, but Your Lordship will just kindly see, when I've written to the corporation, they are telling me that no, you specifically write to the Parks and Squares department.
So you have done that.
I have done that also. There's
Let
no
them take a
response.
decision.
Let them take a decision. Your Lordship.
All right. The petitioner has preferred the present writ petition, seeking a direction upon the respondent number 4 to remove the concrete garden pots installed by them on the footpath of Bara Bazaar, and to further clear the footpath for unhindered pedestrian movement. Installed by them to clear the said footpath for unhindered pedestrian movement at Bara Bazaar. At Bara Bazaar. It is the case of the petitioner that in the year 2024, the respondent number 4 installed this is initially also in your petition you had made them a party.
Your Lordship, the Parks and Squares department, my instructions are yes, Your Lordship.
The
Actually, that was done by the Parks and Square department, and instance it is done because
petitioner respond number 4 installed severe concrete pots, severe concrete garden pots on the footpath, thereby creating obstruction to pedestrian. Full stop. The area in question is already congested, is already severely congested, and the installation of these concrete structure has further worsened the situation and movement of pedestrian in the said area. Full stop. The petitioner had earlier approached this court by way of WPA number 133 of 2024. Full stop. Wherein this court order dated 13th March 2024, restrained the respondent from making any further installation of such garden pots on footpaths, full stop. The court further directed the commissioner concerned to review the issue of such installation of flower pots encroaching upon the pedestrian pathway, pedestrian right of way, kar do. Full stop. Pursuant to the said order, no further pursuant to the said order, learned counsel for the respondent states that no further installation has been done. Full stop. However, the respondent has neither removed the existing concrete structure from the footpath nor has ensured that there is a free flow of pedestrian movement in the said area. Full stop. Despite the petitioner making several representations, the respondents have failed to act upon the same. Full stop. Learned counsel for the petitioner further states that he had received a communication from the Calcutta Municipal Corporation by letter dated 12/7/2024, wherein he has been informed that the appropriate concerned department for the said issue is Park and Square Department, and that his representation is duly forwarded to the said department for necessary action. Full stop. Learned counsel for the petitioner states that he had made a representation before the said department wide letter dated 13th September 2024, but till date no action has been taken, neither any decision has been taken on it. So, no decision has been taken on his said representation. Full stop. Learned counsel for the respondent, KMC, respond number 1 to, you appear for all respondents. Respond number
1 to 4.
1 to 4 states that they are ready and willing to decide petitioner's representation in terms of the order passed by this court in WPO number 133 of 2024 within a period of
that
6.
If I may, I apologize for interjecting at this moment. The Durga Pujas are nearby. Your Lordship has over a year's experience in West Bengal now. Your Lordship knows what kind of havoc could be recorded. Just on account of that.
Within a period of 6 weeks will be before the
end of September.
Within a period of 5 weeks. Within a period of 5 weeks. Within a period of 5 weeks. Learned counsel for the petitioner states that he shall be satisfied if the same is decided within the time specified by the corporation. Full stop. Specified by the corporation. Full stop. In view of the statement made by the counsel for the parties, this court directs the respondent number 4 to decide petitioner's representation dated 13th of September 2024 within a period of 5 weeks, strictly in accordance with law and in terms of the observations passed by this court in WPO number 133 of 2024, after affording an opportunity of personal hearing to the petitioner. By way of a speaking order, with the above direction, the present writ petition is disposed of. Affidavits have not been called for. None of the contentions are put.
Very great.
These are not beautification.
They should have come much earlier. I don't know why they have made so
Your
much
Lordship,
delay.
this writ petition was filed some time back, Your Lordship, of course. And we had filed in March, Your Lordship.
Yes.
A year before.
In item number 23,
Lord, Mr. Chayan Gupta is leading me for personal medical reasons. For personal medical reasons, Lord, he has had to go to Bombay.
Proxy counsel so and so appears and states that the main arguing counsel.
We'll file an affidavit. There's no scope for any interim order subject to Mr. Bandobad.
Possibly there is a scope for an interim order. Kindly excuses me only today for his
Health issue.
And found no.
See, this is how leader of the bar approach your health issues.
one attempt. We should be.
No problem.
Medical issue, Mr.
No, I did not.
Bombay gets medical.
He has gone to Bombay.
Returnable on.
Is indisposed. He prays for a short adjournment. Let this matter be listed on 28th of August.
My Lord, if my Lord's business permits, my Lord can keep it 1 week. If my Lord's business permits.
6th of November.
28th is.
After that, it's only 6th of November.
I was praying for a shorter date, my Lord.
Shorter date will be difficult. 28th
Obliged.
August. Rest of the matters tomorrow. You didn't hear him. You didn't hear him. Medical issue, huh?
Not medical issue of the council. Medical issue of the councils.
Lord, Mr. He will not join issues.
I know.
He will not join
Let
issues.
us not go into.